Good morning, everyone. We'll get started in just a second. I see that many people are still just joining us. Just give it another minute. And we'll get started shortly. Once we hit a critical mass, there are lots of people joining us right now. Okay, well, good morning, everyone. Thank you so much for joining us for the Personhood and Pregnancy Symposium. My name is Lourdes Rivera. My pronouns are she, her, and ella, and I'm the president of Pregnancy Justice. We are one of the co-hosts of today's symposium, along with the NYU Law Reproductive Justice Clinic and the Birnbaum Women's Leadership Center. I just want to make a note that in the middle of my remarks, I will provide the CLE code for this opening session for those who registered by October 2nd and wish to request continuing legal education credits. And also one of my colleagues will be also dropping links for relevant resources during these opening remarks. So we have an exciting lineup of discussions today from scholars and advocates from across the country. They will be presenting their articles that will appear in a forthcoming dedicated online edition of the NYU Law School's Review of Law and Social Change, also known as the Harbinger. But before I jump in, I want to thank a few people. Jennifer Weiss-Wolf, Kelsey Kinoshita, and Sherry Arnold of the Birnbaum Women's Leadership Center, Professor Sarah Wheeler, as well as Camille Claudel Bronson of the NYU Law Reproductive Justice Clinic, the NYU Law Review of Law and Social Change student editors, Maeve Wiesen and Sydney Jasowitz, and current and former students of the Reproductive Justice Clinic, Maeve Wiesen again, Abigail Hoover, and Sunil Tohan, who will be moderating each panel today. So for nearly 25 years, Pregnancy Justice has been defending and advocating for the civil and human rights of pregnant people, no matter if they give birth, experience a pregnancy loss, or have an abortion. One of the greatest threats to this fight is the decades-long effort to imbue fertilized eggs, embryos, and fetuses with legal rights and status, the same legal rights as anyone here today, and to the detriment and the eclipsing of the very personhood and legal status of the actual person who is pregnant. This often is referred to as fetal personhood. And while it's easy to use this shorthand, we do it all the time, at Pregnancy Justice, we try our best not to use the terminology for a few reasons. One is that public opinion polling that we conducted this year with the National Women's Law Center shows that most Americans don't know what fetal personhood means, and we lose them when we use this language. However, once it's explained and people understand what we're talking about, our polling shows that Americans really do not like this concept. Second, the use of the term cedes ground to opponents of this theory. When we adopt their language, we are forced to play on their court. And our work at Pregnancy Justice and with all of you today is to continue to reframe the narrative, to center and assert the full and complete personhood, bodily autonomy, and constitutional and human rights of pregnant people, of women, of all people with the capacity for pregnancy. This work has never been more urgent. While these fights are not new to us, post-Dobbs, establishing full legal status for embryos and fetuses through federal action, state laws, or judicial decision has become the next frontier of the anti-abortion movement. And what this means, if they succeed, of course, is that abortion could be banned nationally, along with some forms of birth control. There would also be restrictions on IVF, and we saw a preview of this with IVF endangered in Alabama last year, where the state Supreme Court held that a frozen embryo is the same as an extrauterine child under the state's wrongful death statute. While the statute was amended by the legislature in response, the state's so-called Sanctity of Unborn Life constitutional amendment, adopted in 2018, remains a threat. And more pregnant people experiencing obstetric emergencies would be forced into organ failure, to the brink of death, or actual death in the name of protecting the rights of the fetus. We know of at least 5 women who already died: Amber Thurman, Candy Miller, Portia Ngumezi, Gisele Barnica, and Nevaeh Crane, and there are likely others who we'll never know about. And we saw this summer in Georgia in the case of Adriana Smith and Marlise Munoz in Texas in 2014, 2 women who were declared brain dead. Pregnant people's bodies could be further abused by being hooked up to machines without consent or without any input from their families in the name of protecting fetal life. This should not be the lot in life for pregnant people. Rather, they deserve timely, quality healthcare interventions and equitable treatment that they need and decide on to ensure their health and lives. But we know this is not about providing care. This is instead about surveillance and control of supposed bad moms, because pregnant people are expected to be completely self-sacrificing to fulfill their roles or be punished. And this is not hyperbole. Our analysis shows that in the last legislative session, we saw an unprecedented 15 bills introduced across the country seeking to make abortion a homicide offense that could be charged against the abortion seeker. And in 12 of those states, the death penalty could be pursued. And at the same time, we are seeing attempts to erode birthright citizenship under the 14th Amendment for the actual persons born in the United States. So while this is happening, we saw bills introduced in 16 states that would establish equal protection rights for embryos and fetuses under state constitutions. And some of these are overlapping with the abortion as homicide bills that I just mentioned. And this is by far the highest number of bills of this kind introduced in any legislative session. And while none of these passed thus far, just 9 days ago on October 1, the South Carolina legislature convened a special hearing to push one such bill forward. Advocates in the state are fighting as hard as they can. It really is a test for these equal protection and abortion as homicide bills. The most tangible manifestation of giving legal rights to embryos and fetuses is the way it leads to pregnancy criminalization. Pregnancy Justice just released its latest data on pregnancy criminalization in the first 2 years after the Dobbs decision. Our research identified over 400 women who were charged with pregnancy-related crimes in those first 2 years. This data is still preliminary and an undercount, and we will be updating it periodically. Nearly all cases involve the use of criminal statutes that and the bringing of charges that were never intended to apply in the pregnancy context. State criminal statutes on child abuse are being interpreted to include embryos and fetuses in the definition of child. And it is not surprising that the 3 states that consistently appear to be doing this at the highest rates, meaning Alabama, Oklahoma, and South Carolina, are the same states in which the state Supreme Courts have designated fetuses, and in the case of Alabama, embryos from the moment of fertilization, as children under their criminal laws. And then an additional 14 states have done so by statute. And it's also no mistake that the states with the worst record of punitive treatment of pregnant persons are among those with the worst maternal and infant mortality and health outcomes. For example, the Kaiser Family Foundation identifies Alabama, which based on our data leads the nation in pregnancy criminalization, as having the 2nd highest maternal death rate in the country and the 3rd highest infant mortality rate. In fact, the top 3 states for pregnancy criminalization in our data set rank among the top 11 in maternal death and top 10 in infant mortality, which tells us what the priorities are here. Pregnancy Justice's mandate is to continue to not only educate the public about this threat, but to conceptualize an alternative framework to not play on their court. The human rights framework of reproductive justice, which we adopt and which was developed in 1994 by a group of Black women in response to the too narrow focus on abortion and choice framework, offers one such alternative. Reproductive justice, as defined by Sister Song, demands the human right to maintain personal bodily autonomy, to have children, to not have children, and to parent the children we have in safe and sustainable communities. Reproductive justice requires a broader approach to confront the overlapping systems of oppression and historical legacies that devalued the personhood and family structures of women of color, Black and Indigenous women in particular, as well as gender diverse people, poor people, people with disabilities, immigrants, and young people. Reproductive justice is a critical response to fetal personhood, because fetal personhood is not only an attempt to eviscerate abortion rights, but also a mechanism to justify the elimination of women from the public sphere. And combined with the pronatalism responses to our diversifying demographics, elevating the rights of embryos and fetuses above that of the pregnant person also serves to force white middle-class women to repopulate the nation, while Black women and women of color, as well as poor white women who are seen as harming white babies, can be left to suffer, die, or endure family separation and other state abuses. It is also very intentionally appropriates the language of Reconstruction amendments to seek to establish equal protection for embryos and fetuses. It's no coincidence that the proponents of this ideology have co-opted the anti-slavery movement's language and proudly calls themselves abortion abolitionists. It's corrosive to gender equality and to our democracy. So I'm going to pause here and give you the public service announcement and share a code for CLE credit. It is fittingly toward liberation. So I repeat, it's toward liberation. Please mark that on your CLE forms if you're seeking CLE credit. So today's symposium is the culmination of a nearly 2-year-long partnership and effort between the NYU Reproductive Justice Clinic, Birnbaum Women's Leadership Center, and Pregnancy Justice. About 1 year ago, we gathered 80 scholars, advocates, activists, law students for a 2-day in-person pregnancy and personhood convening at NYU Law School, where we started to build connections across issues and issue areas to address this growing threat and develop alternative frameworks. We hope the scholarship that you'll hear about today will continue to inspire more thinking, more strategy, and more focus on this critical issue. Our work today is to consider the historical context of this fight and present and our present challenges, and imagine new mechanisms and legal theories to ensure that pregnancy cannot be wielded to reinforce patriarchal and racist systems of control. And before turning to the rest of the program, it's important and right to recognize someone who should be here with us today, but who isn't. This work simply could not have been possible without the vision, dedication, and brilliance of Professor Sarah Burns. Sally, to those who knew her, passed away last month. Sally was the founding director of the NYU Law Reproductive Justice Clinic and a longtime board member of Pregnancy Justice, including as board chair. She dedicated her career to this work and mentored generations of students and lawyers, including many of us at Pregnancy Justice. In fact, she hired and mentored me for the first 1.5 years of my tenure as president. Sally was a member of the inaugural class of the Georgetown Women's Law and Public Policy Fellowship Program. She later served as legal director of the National Organization for Women's Legal Defense and Education Fund, where she skillfully brought women's voices to bear in reproductive rights Supreme Court cases through first-person narrative amicus briefs. Sally was also a trailblazing lawyer who persuaded courts to recognize sex discrimination and sexual harassment as harms that the law could remedy. She joined the NYU law faculty 35 years ago, and through her work as a clinical professor, she shaped generations of students. She co-directed the Civil Rights Clinic, founded the Mediation Clinic, and taught in several others before creating and leading the Reproductive Justice Clinic for the past 12 years. Her vision for that clinic anticipated a national movement that has since taken shape, including a focus on pregnancy criminalization that has only become more urgent. She brought unmatched skill in grassroots lawyering, impact litigation, policy advocacy, and client representation to her teaching, and she shared those skills generously. Sally truly was a giant who stepped softly. She was loved, and she will be missed by so many. Her presence and impact is felt deeply today. We honor Sally by continuing this work, by remembering that it is hers and so many other shoulders that we stand on. And the forthcoming edition of the Harbinger, in which these articles will be published, will also feature a dedication to Sally, authored by Reproductive Justice Clinic Professor Sarah Wheeler. Thank you for listening and being part of honoring Sally today. Now, I want to orient you on the rest of our time together. We have 3 exciting discussions today that feature forthcoming scholarship, which we have organized into 3 panels based on how these topics complement one another. Each panelist will present a short summary on their topic, and then the moderators will facilitate a conversation among the panelists, and you can participate in this discussion as well by submitting questions using the Q&A function. You should have received materials earlier this week via email that include forms to complete for CLE credit. Each moderator will share both verbally and visually, like I did, the CLE code that you must include in your form at the conclusion of this symposium to receive the CLE credit. You can submit your completed CLE form by responding to the email sent earlier this week by Camille Claudel Bronson, that's Camille with a K. And if you have any questions about this, please contact Camille if you wouldn't mind dropping your email in the chat. And we encourage you to continue beyond today to partner and connect with Pregnancy Justice. Please sign up for our newsletter if you haven't already. You'll learn of ways to take action, join us at events, and other opportunities to engage in this work. And with that, we're going to kick things off with our first panel, a legal reimagining of pregnancy. So that's a legal reimagining of pregnancy, which will begin shortly at 9:50, and we'll see you there. Thank you.
Hi, everyone. Thank you for joining this morning. I think maybe we'll just give like a minute or 2 more for people to get settled. For the panelists, if you'd like to put your pronouns in your name, you can do so by renaming yourself in Zoom if you'd like, but no worries if not. But I think we'll start in maybe a minute or so. Okay, I feel like we can get started if that's okay with everyone. So hi everybody, my name is Sunil. I use they, them pronouns. I am a student at NYU. I am in the Reproductive Justice Clinic, and I'm here to moderate a very wonderful set of panelists and talk about really cool scholarship that they've all written. The panel is titled A Legal Reimagining of Pregnancy. We have a group of legal scholars joining us who've written really innovative pieces about bodily integrity, reproductive freedom, criminalization of pregnancy, Marxism, Black feminism, all of which discuss sort of broadly first how pregnancy has been legally reimagined to lead to state control, and also suggest how we can sort of reclaim and reframe pregnancy in support of reproductive justice. So we're going to hear from each of the authors with a summary of the papers that they've worked on. And then we're going to have a conversation amongst everyone that's guided by questions. So for everyone watching, feel free to submit questions via the Q&A feature at any time throughout. And I'll be looking at those questions and we'll pose them to the panelists in this sort of like moderated question and answer format after the summaries. So for those of you who are looking for CLE credit, stay tuned for that code halfway through the session. I know someone asked about whether there'll be like a recording and like links shared later. That's definitely happening. The session is recorded and links will be shared, so stay tuned for that. So without further ado, I want to start with the first paper, which is titled The Law of Pregnancy, Carceral Logic, and Fetal Personhood, which has been worked on by Professor Kimberly Mutcherson at Rutgers Law School in Camden and Karen Thompson, who is the legal director at Pregnancy Justice. So thank you for joining us.
Morning, Sunil. Thank you so much for being our fearless leader this morning. I'm really looking forward to the discussion that we're going to have. So I get to go first, which is always the best position to be in when a panel starts. I'm super grateful for that. And I'm really excited to talk about the piece that I was able to write with Karen Thompson, who is a force of nature. You should all know her and know her work. So our piece is a piece basically that is drawn from a couple of places. I'm a person who has been teaching a course at my law school called Bioethics, Babies, and Baby Making for about 20 some years now. And one of the things that I do with my students at the beginning of the semester is ask them to interrogate this basic idea, right? And that idea is that pregnant bodies are public bodies. And I've been doing that for a really, really long time, but I've never actually written anything about it. And so this was an opportunity to do that and to do it along with Karen. And so, really, what I mean when I talk about pregnant bodies as public bodies is that there's something about pregnancy, and we don't have time to run through all of it now, but there's definitely something about pregnancy that has allowed the law over time to determine that once someone is pregnant, they lose some element of what it means to be a person, what it means to be somebody who has bodily autonomy, what it means to be somebody who has bodily integrity. And so certain bodies then become bodies that belong to the state and not to the people who actually live in them. And the other piece that's really important here is that abortion law, much to our detriment, I believe, is basically the cornerstone of pregnancy law in the United States, right? And if you were going to just start from scratch, you wouldn't start with abortion when you were thinking about what's the law's relationship to pregnancy. And yet that's what we've done, which is basically the worst way to construct law related to what it means to be a pregnant person and how to protect people who happen to be pregnant. And as Lourdes talked about in her opening, I think the new bill in South Carolina is a really good way to recognize all of the faults that flow from having pregnancy being regulated only through, or mostly through, the lens of abortion. So Karen and I, as we were thinking about our piece, we wanted to really think about this idea of pregnant bodies as being public bodies, and we wanted to imagine what the law could or should look like if we were working with a different paradigm, right? We've been so focused on privacy, hasn't worked for us. Courts have not been interested in the idea of sex equality as a way to get at these issues involved with pregnancy. And so our challenge was, we are in this moment where there are opportunities to try something new, to try things that are innovative, and so we wanted to throw something innovative and challenging out there into the world. And that's what we came up with. And I'm now going to throw it to Karen to talk about what we came up with.
Hi, good morning. Sorry, very awkward fumbling with the unmute button. So fetal personhood is, as you've heard already several times, the radical theory that a fertilized egg or fetus has the exact same rights as you and me, and that has justified forced C-sections, criminal charges for child endangerment against pregnant people, compulsory life support for brain-dead women, and abortion bans. Fetal personhood tries to make it normal for a woman's rights to be erased by a non-existent person and for the government to have an interest in what it deems to be its property or the contents of a womb. So given the failures that Professor Mutcherson just laid out and the increasing fetal personhood threat, a paradigm shift in the narrative around what property is and who defines it is necessary, because Josh Craddock, the new Deputy Assistant Attorney General for the DOJ's Office of Legal Counsel, recently wrote in a law review article that before Roe, states widely recognized unborn children as legal persons in property law. So shifting this dynamic and this paradigm requires self-possession or a reverse taking of the body. And this is something that has a real root in a long, long tail of legal jurisprudence. John Locke asserted that every man has a property in his own person. James Madison espoused this idea of a property interest in one's own body, arguing that property embraces everything to which a man may attach a value and have a right. So making self-possession a constitutional guarantee and thus a weapon against fetal personhood, which at its essence is a taking of the pregnant body, has a path through the Ninth Amendment, which, along with its state analogs, states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. A pregnant person's proprietary right to their own body is an unenumerated constitutional right covered by the Ninth that would resist pregnancy criminalization, protect abortion, and reject the imposition of fetal personhood principles across all aspects of life, legal, medical, or otherwise. As the Supreme Court named in Union Pac v. Botsford over a century ago, no right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others. The Eastern District of Texas noted in 1971 that the framers' purpose in adopting the Ninth Amendment was to retain for the people, such privileges and immunities complemental and parallel to the enumerated rights as might be essential for the preservation and promotion of human dignity and liberty. In the past legislative session, as you heard from Lourdes earlier today, 11 states proposed bills making abortion a death penalty eligible crime, all justified through fetal personhood laws, which erase the personhood of pregnant people, pregnant trans men and non-binary people. It criminalizes and destroys pregnant people in favor of their pregnancies. So bodily autonomy is an essential right for the preservation and promotion of our human dignity and liberty. It is a fundamental possessory right to one's own body, free from interference, including from the government. And that is an unenumerated right that we need to recognize in ourselves, that we need to recognize our power in the Ninth Amendment and to act accordingly. And I just want to, my dear friend, Indra Lucero from Elephant Circle has already created the swag. We're going to demand our rights under the Ninth and try to use an activated constitutional power to bodily autonomy.
Thank you so much. That was really interesting. So I want to remind everyone to carry on putting questions in the Q&A so that we can address those later on. But we're going to move to the next summary and then come back to Q&A afterwards. So the next article is titled Maryland Reproductive Freedom and the Full Personhood of Pregnant People by Margaret Johnson, who is Professor and Associate Dean for Faculty Research and Development at the University of Baltimore School of Law.
Thanks, Sunil. Can everyone see my slides okay? Is it working? Yeah. Well, thanks so much. And thanks to all of you and your colleagues, the student editors at the Law Review, the Review for Social Change, for putting on this incredible symposium, and to the other organizers. As Lourdes talked about, Pregnancy Justice has really done an incredible job of documenting the pregnancy criminalization and how it's increased since Dobbs came down. It can cause heightened punishment for actions that would not be penalized or would be penalized less severely if committed by non-pregnant persons. And often there's no proof of harm to the fetus, effectively criminalizing the pregnancy itself. It can result in unnecessary and harmful entanglement with the criminal legal system, incarceration, and family separation, as Lourdes mentioned. And I come from Maryland. I teach at the University of Baltimore School of Law, and pregnancy criminalization happens in Maryland, a blue state. Maryland's constitutional amendment that's brand new for reproductive freedom, I argue, goes beyond abortion protection and offers opportunities for addressing pregnancy criminalization by state actors. And this will enhance the recognition of the full personhood of pregnant people, their liberty and equality, and around their bodily integrity, behavior, and decision-making with superior rights to non-person. Nationally, after Dobbs, Pregnancy Justice has documented that 282 pregnant people have faced criminal charges for conduct associated with pregnancy, pregnancy loss, and birth. A justification for this criminalization is the state's interest in potential life or life of the unborn, especially post-fetal viability. The legally significant line drawn in cases Roe and Casey that were overturned by Dobbs. And states have provided rights to fetuses, as Lourdes talked about, as persons justifying state intervention in a pregnant person's pregnancy or birthing for the alleged safety of the fetus. The legal significance of fetal viability supports the growing recognition of fetal personhood rights that diminish this personhood of pregnant people and often causes the criminalization of pregnancy. So these harms from criminalization are vast, including deterrence for pregnant people seeking prenatal care or treatment for substance use, separating children from their birthing parents, disproportional criminalization that targets poor, Black, and white pregnant people, and as I said before, criminalizing even when there's no harm to the fetus. In Maryland, prosecutors have convicted pregnant and birthing people under such a large number of criminal statutes that I won't get into for the interest of time. And while some of these convictions have, thank goodness, been overturned on appeal, the pregnancy criminalization nonetheless causes a loss of liberty. So Maura Akers was convicted of second-degree murder and first-degree child abuse for an alleged stillbirth. Her conviction was overturned after 3 years of incarceration, and she is set for a new trial. Prosecutors relied on her internet searches about terminating a pregnancy and her lack of prenatal care. And with this evidence, the prosecution was linking consideration of an abortion to intent to murder a baby after its birth. That's bonkers. And importantly, the Supreme Court overturned the conviction and even stated Maryland law recognizes the fundamental difference between a fetus and a baby and rejects the concept of fetal personhood. But the court did not, in fact, recognize full personhood for pregnant people in two ways. It stated that non-viable fetuses are not persons, but of course, it should have also said that viable fetuses aren't persons either. In addition, in recognizing that a pregnant person has a right to not seek prenatal care, the court said that it was uncomfortable holding that disparate prenatal care, meaning seeking prenatal care for one pregnancy but not another, would never be relevant. In November of 2024, 76% of Maryland voters supported the new constitutional amendment for reproductive freedom. And that constitutional amendment states that every person, as a central component of an individual's rights to liberty and equality, has the fundamental right to reproductive freedom, including but not limited to the ability to make and effectuate decisions to prevent, continue, or end one's own pregnancy. The state may not directly or indirectly deny, burden, or abridge the right unless justified by a compelling state interest achieved by the least restrictive means. And of course, this is so new, the courts have not yet interpreted it. I argue, based on a textual analysis of the constitutional amendment, the legislative history, because this first originated in the statute that then was sent to voters to support, as well as the existing laws and regulations that exist in Maryland, that the right for reproductive freedom should be interpreted as being held only by the pregnant person throughout their pregnancy and supreme to any state interest in potential life. And I do this because I make this argument because I find that, for instance, when we're talking about the compelling government interest in the amendment, we are no longer bound by the federal constitutional interpretation of strict scrutiny. This is a brand new right that doesn't exist in the federal constitution, giving Maryland courts the right to interpret it specifically based on reproductive freedom. And that compelling government interest in narrowly tailored means should be interpreted distinctly from the federal constitution. In addition, the equal protection that's offered in the Reproductive Freedom Amendment should be interpreted distinctly from like Dobbs or Skermeti when, as Kim and Karen just were discussing, really narrowed sex equality as related at least to abortion and gender affirming care, perhaps. And
Margaret,
finally,
sorry, I
yes.
just wanted to flag that your slides are not advancing. Sorry to interrupt you.
Oh, they're not advancing.
Yeah, I'm so sorry.
That's interesting. Let's see. Well, that's fine. I'm sorry
Okay.
about that.
No.
I don't know why that is. Okay, well, I also argue that on the first slide, if that's what you're seeing, that there's an affirmative right, not just a negative right to stave off state intervention, but also to provide to obligate the state to provide governmental support. And what this would look like in the context of pregnancy criminalization would be that the constitutional amendment should support that there's no compelling government interest in protecting a fetus if it interferes with the pregnant person's right to reproductive freedom, and that the government's obligated to use least restrictive means if it does in fact go towards criminalizing pregnancy or birthing. And that would be at a minimum that there'd be informed consent for testing, that they'd have to use valid drug testing methods, that they would have to exclude prescribed medications for substance use, and they would need to use similar methods for testing as they would use for non-pregnant people. In addition, there should be no discrimination against pregnant people simply because they're pregnant. They need to be equally treated to non-pregnant people. And finally, regarding that affirmative right, the state should be obligated to provide prenatal care, support for those experiencing substance abuse or use, and use non-separation methods for addressing infant needs if they're born with like a substance exposed newborn. So I look forward to discussion, and thank you for this opportunity. Sorry about my slides.
No worries. Thank you so much. It was very easy to follow, even without the slides. So thank you. Our next paper is titled True Abolition: Dismantling Criminal Abortion Laws and Building Policies to Realize Reproductive Justice by Cindy Soohoo, professor at CUNY School of Law.
Thanks so much. And thanks to NYU Review of Law and Social Change and Pregnancy Justice for organizing this amazing symposium. I'm going to be talking more about criminalization than reimagining, I'll just present and then I can add more later about reimagining pregnant bodies. So since Dobbs as we all know, states have really rushed to enact criminal abortion laws. Today, over 30 states have laws criminalizing abortion care, yet the appetite for more and harsher criminal laws continue unabated. Currently, as we've discussed, I think already, abortion abolitionists seek to impose murder charges for having an abortion. Internationally, the trend has been very different. Over the last decade, international human rights bodies have repeatedly condemned criminal abortion laws. And reflecting countries' negative experiences with criminal abortion laws, there's been a green wave of countries liberalizing their laws. These countries have found not only that criminal abortion laws violate the rights, dignity, and autonomy of pregnant people, but also, as a practical matter, they don't prevent abortions. And they impose serious negative impacts. We know that criminalization itself imposes severe harm, but it also, as we've discussed, right, it endangers people's health and lives because of the denial of care in obstetric emergencies, and especially before people learned about how to self-manage using abortion pills, the use of unsafe methods resulted in high rates of maternal mortality and morbidity around the world. The rest of the world also recognized that the criminalization and health risks disproportionately impacted the most vulnerable communities. So for these reasons, the high courts in Mexico and Colombia struck down criminal abortion laws, even though they, unlike the United States, actually recognize a state obligation to protect life, including prenatal life. So instead of criminal laws, they encourage the state to adopt policies to protect prenatal life that also respect the dignity, health, and rights of people who are or who can become pregnant. So 3 years after Dobbs, our experience, not surprisingly, with criminal abortion laws is pretty much the same as the rest of the world. Abortion is not decreasing. Criminal laws are undermining healthcare for pregnant people and turning people away from healthcare providers. I think, fortunately, due to the outstanding work of abortion funds, support groups, innovative providers, the abortion shield laws, these have all mitigated the harms that we could have seen in the United States. But it is really unacceptable that we're experiencing deaths, delays, denials of care, compromised care that are entirely preventable and in fact are created by criminal abortion laws. So what is stopping? So what I was interested in is what's stopping the US from learning the lessons that most of the rest of the world has? Why can't we turn away from criminal law? So my article discusses 3 obstacles. The first is the impact of gender stereotypes and the corresponding failure to recognize women and pregnant people as full rights holders. The second is the impact of prenatal personhood rhetoric. And the third is the lack of support for government programs to support the health and welfare of pregnant people and families. So I only have 7 minutes, so I'm going to quickly summarize the first issue and then focus on the other 2. One of the factors that I think led the courts in Mexico and Colombia to reject criminal abortion laws is that they take the rights of women and pregnant people seriously. They recognize that criminal abortion laws violate multiple human rights. And really, they weren't looking to, is there a right to abortion in the Constitution, but they recognize that denying access to abortion violates multiple human rights, including the right to health, the right to life, the right to non-discrimination, autonomy, privacy, freedom from cruel, inhuman, and degrading treatment, and gender-based violence. They also recognize that criminal abortion laws are rooted in stereotypes about women's natural roles. And both countries have constitutional commitments really rooted in their human rights obligations to dismantle gender-based stereotypes. So in the US, as the Supreme Court has diminished the rights of pregnant people, claims on behalf of prenatal life continue to grow. And we've talked about this already, right? Prenatal personhood claims asserting that really zygotes, I don't like to say fetal personhood, I like to say prenatal personhood, asserting that zygotes, embryos, and fetuses have the same rights and legal protections as legal persons is often really the main justification for criminalization. The claim is because embryos and fetuses are people, abortion must be prosecuted as homicide. And the most extreme abortion abolitionists call for the death penalty for women who have abortions, right? This is clearly not pro-life. Abolitionists purposefully conflate recognition of the value of prenatal life, which many Americans agree with prenatal personhood, which most Americans do not. In Mexico and Colombia, again, where the state has an obligation to protect prenatal life, the courts have recognized the difference between a state interest in protecting prenatal life and personhood and explicitly reject prenatal personhood. The courts also refused to presume a conflict between pregnant people and prenatal life, and that assumed conflict in the U.S. is used to justify state intervention. Instead, the Mexican court wrote, only by caring for the rights and well-being of pregnant people can the state protect prenatal life. And I can go more into that later, but I just want to cover the other point in my piece. So this leads to the third point. Rather than using criminal law, the Mexican and Colombia courts urged the state to develop policies to provide information and resources to prevent unwanted pregnancies, to ensure access to the full scope of sexual and reproductive health care, and to provide material support to ease the burdens of childbearing and parenting. So most scholars, I think including many people here, have written about how the states with the most restrictive abortion laws have the fewest supports for families and for sexual and reproductive health. So why is it that pro-life legislators assume that prenatal life can only be protected by taking away the rights of pregnant people through coercive actions like criminalization, instead of investing in programs to prevent unwanted pregnancies and to make childbearing and parenting more affordable and accessible? In Mexico and Colombia, the state actually has an affirmative obligation to help ensure that people have the resources to realize their rights. So I think that's one difference, but I don't think it's just a legal distinction. The lack of will to invest in social programs in the United States, I think, reflects the anti-abortion movement's historical alliance with the Republican Party, which has touted fiscal as well as social conservatism. And in addition, as Dorothy Roberts and other scholars have written, in the US, racism is really intertwined with neoliberalism to diminish support for social programs to help poor families. So in conclusion, I think that most Americans think abortion should be legal in all or most cases. At the same time, many favor government action to prevent prenatal life. Often this is presented as an insurmountable conflict. I think the decisions of the high courts of Colombia and Mexico illustrate, I think there's room for common ground around policies that protect prenatal life and support the rights of people who are or can become pregnant. A starting point has got to be the rejection of carceral approaches. Criminal abortion laws violate the human rights of people in need of abortions. And as experience has shown in the US and around the world, they don't prevent abortions and they impose real harm. A more inclusive thing to do would be to bring together some pro-life people and a reproductive justice frame, which could be designed around positive state programs to ensure that people have access to sexual and reproductive services, to decrease the need for abortions, that families have the support they need to raise their children in safe and healthy environments, to make it easy for families to choose to continue pregnancies, and that pregnant people have access to appropriate prenatal care. So I'll stop there.
Thank you so much. Our last paper before we move into a conversation and a Q&A is titled Reproduction by Professor Zanita Fenton of the University of Miami School of Law. Thank you for joining us.
Thank you, Snell. Good morning to everybody. And let me first say how excited I am to be on a panel with such illustrious speakers. I've met or I know all of you throughout my career. And so my only regret right now with the virtual panel is that I don't get to give you all a hug. And that goes for you too, Sunil. I'd like to meet you in person. But let me get on to my actual remarks. My summary. So from the beginning of teaching, especially gender issues and reproductive rights, is the use of labor and labor, reproduction and reproduction. And since I can remember, we've always thought of this as a joke. Isn't that funny? But it's not. The terms mean the same thing in both contexts. So I took the confluence seriously to situate reproduction as an integral part of markets. That is, within the reproduction of labor and capital. So now here's the double meaning, another double meaning that I will focus on very soon, breeding and breeding. During the same period that Karl Marx formed and wrote his theories of capitalism, coincidentally was at the height of slavery in the United States. Part of Marx's theories is about the natural function of the elements of capitalism to reproduce. What makes his ideas concrete are the breeding operations used as necessary to prolong slavery after the importation clauses permitted Congress to ban imports. So breeding practices were used along, of course, with sexual subordination imposed on the freedoms of Black women. And breeding was intended to reproduce low-income low-income labor. During this period of time, marriage regulation restricted the sexual and reproductive freedom of white married women, though not with the same impact, not the same severity or consequences. Both, assuming a binary here, were exposed to expected to reproduce, one to supply cheap labor, the other to birth heirs, that is, to produce the protectors of family wealth and future capital holders. It is not just labor and capital that are reproduced, it is the social status hierarchy as linked to the forms and initiated through racial classifications that continue to mean that race is an imperfect proxy for poverty and wealth that we continue to experience. I made a statement from a forthcoming piece, which I'm not usually interested in self-promotion, but the piece that's about to be published, like any second now, is so relevant to the agenda and the serious work of all of the panelists and the entire conference that I have to mention. Rebirth of a Nation, Reconstruction's Unfinished Business will very shortly be published in the Michigan Journal of Race and Law. In that work, I made a statement that bans on pregnancy terminations are designed to ensure a continuous supply of low-wage labor. I got grief for that. So several people who read drafts, who read almost finished piece, like, where'd that come from? Why'd you say that? I'm like, well, isn't it obviously connected to my full discussion about breeding? But then I realized their issues was really about how I could say that today. But I can, because everything that happened then has been repeated and repeated and repeated, and we're still stuck in a similar situation. Our status quo has not appreciably altered. Yes, I'm grateful that we do not have slavery. Yes, I'm grateful that I cannot be raped on a whim on a regular basis. I'm grateful, even though it was not part of slavery, that married women, by and large, can make claims of marital rape. But now I ask you to consider two things. One, the state of affairs prior to Roe, that is, flights to Paris, or DNCs, we would call them, if you had money, or wire hangers if you did not. And that's what I feel like we're back to. We're there again. And so if the situation at enslavement was similar to now, this is one of the ways that we see that. Technology is the next place I'd like us to focus, which I know others of the panel have discussed some of these technologies, but I view the medical ability to terminate a pregnancy as a reproductive technology. It is now banned to those who don't have money, but for those who do have money, they still have access. If we consider the other technologies, the ARTs, the assisted reproductive technologies, by and large, those are accessible also by individuals with wealth and money. That is, artificial insemination can give you a designer baby and can even help you avoid stretch marks if you use a surrogate. Well, where might that surrogate come from? Someone typically who's in poverty. Surrogacy is perhaps the most comparable to slavery, as a gestational surrogate is needed only for her labor and has no rights. It may be regarded similar to the slave practice of wet nursing. Though not technology, adoption is also very important. Every time you hear someone say, well, the bans on abortion are good because now we'll have more babies to adopt, don't take into account that we value babies differently. And why don't they think when they suggest this about the obvious comparison of baby selling? Isn't that what we're also talking about? Also hearkening to slave practices. The inherent power dynamics of both adoption and surrogacy have also led to cross-border negotiations, cross-border contracts, and have given rise to adoption tourism and surrogacy tourism that enable wealthy parents to acquire white-appearing babies. Those are the comparisons that I put out there. We've got two types of technologies that we are accepting, and both of them are for the benefit of those who have wealth, by and large, white and wealthy, by and large, impoverished, and persons of color. I thank you for your time. I look forward to the remainder of questions and remarks.
Thank you so much. Wow, I feel like Zanita said, this is a very like illustrious group, and it's so cool to have you all here together and to be able to have the second half of like a conversation right now. Um, so I want to like pose some questions that the clinic has been thinking about, and then also questions that um, audience members, attendees have put in the Q&A. Before I do so, I want to flag for the CLE credit for people who are interested in that. The code is reclaim and reframe. If this is visible, is everybody? Reclaim and reframe for those who are interested in CLE. Sorry for that interruption. So yeah, I would love like a open dialogue, but I do have questions, and I hope, you know, everyone feels comfortable to answer all questions, and some are targeted for specific papers. But since we just ended with Zanita's paper, I do want to ask you kind of about like form and like inspiration. I think that just reading your article directly after Cindy's, for example, where Cindy's makes very concrete policy recommendations and relies on like legal cases, and yours relies on Marxism and Black feminism and critique that is not necessarily legal in nature. And you just mentioned you were like given grief for like making some of these claims that were more theoretical, if you want to frame it that way. I just like want to hear your thoughts on being a law professor that engages with things that aren't just case law. And what do you think the role of these schools of thought are in legal imagining, litigation, lawmaking?
Thank you for that question, Sunil. So first off, is ever since I've been teaching, I've never imagined the law to be in a vacuum. It is part of society, so everything that is relevant to our social issues is relevant to the law. Law has both been a participant and a blockage, a barrier, and sometimes a facilitator for the things that we all want to talk about. Another way to imagine what I've done, because I reject that my piece is less legalistic. It is very legalistic. It's historically legalistic,
Mhm.
meaning that you might view mine as origin story that makes the work, the fabulous work that Cindy just told us about, as necessary. And so whether she does or somebody else relies on the stuff that I put out there, it's needed so that we've got the justifications, we've got the pathways to say, no, we need to do this, not that. And so they work together. And in other words, we need us both. We need both approaches. We need, in this conference, we need every single approach and idea that we can get. I think
Cool.
I've answered all of your questions, but
Yeah,
not
that
sure.
makes sense. Yeah, yeah. Thank you.
Okay.
Can I chime in also? Because
Please, yeah.
I mean, I think that like scholarship and theory is incredibly important. And I know you were just trying to be provocative and get that both are
Yes.
important. But you know, I really think, you know, as we were all discussing, right, part of the problem today is like the rhetoric around prenatal personhood, right? And I think that we need to um, re and sort of this assumption really that I think we need to examine that there's a conflict between pregnant people and prenatal life. And I think in order to do that, we need theorizing is really important. And you know, in my piece, I cite, you know, feminist scholarship has always like recognized that the law fails to properly capture the pregnant body, right? And Megan Megan Boone has talked about how the law assumes that we are all autonomous individuals in a single body, right? And that's sort of been the assumption of the U.S. legal system, right? And then it poses a problem because it doesn't account for the pregnant body, right? And then when you give rights to a fetus, then it automatically takes away from the rights of the pregnant person, right? I think that's what we're all sort of discussing. So we need a new way to theorize the pregnant body. And, people are sort of talking about, and that's sort of what the Mexican court was saying, right? That we can only protect prenatal life by protecting the pregnant person. And so, like, different theories would be that there's one dyad or one entity, right? And that rights flow through to the prenatal life through the pregnant person, and that we only protect prenatal life by protecting the prenatal. But I mean, I think this is all related to theory, right? We sort of need to develop new theories, new ways to understand, because like we've been sort of pigeonholed into something that honestly doesn't make sense,
Mhm.
right? So I
And on
think,
that,
yeah.
if I could chime in one more time, because you said some such important things that I think resonate throughout the comments of other people. We need to reclaim some of the language that we're talking about. I feel gratified that people keep saying pregnant persons. Even though I hate it out of Goodell Dog, even though I hate it out of Dobbs, we need to reclaim that because we are talking about persons. Women are people. We're not just vessels, which is what Goodell Dog and Dobbs makes us feel like. Women are merely vessels. And then when we talk about fetal rights and such, it's fascinating to me that we've got this wave of trying to get rights to these non-existent persons, even though throughout history we've infantilized women such that women are not granted the same level of rights as other persons. And so re-co-opting that language, I think, is ultra important. And our theories help us get there, not just our laws. And so I agree with you again, Cindy. I will be quiet now.
No, no, no. Thank you so much. This is a really interesting conversation. I think this is bringing up something that relates to other questions that people are posing, which is like this thread about language and like reclaiming and the way we talk about all these concepts. And Cindy, you mentioned like this prenatal personhood thing. There was a question in the chat about whether people today on the panel have ideas about like messaging in terms of like nomenclature and how we can really understand fetal personhood laws and policies, because that framing even makes it like sort of difficult to understand. I feel like Karen from Pregnancy Justice might have like work experience in this. So yeah.
Yeah, it's tricky. We recently did polling with the National Women's Law Center around the whole question of fetal personhood to understand how, folks were really receiving it, because it is weedy. It is in this kind of like legalese space. And what we found out was that, yeah, people aren't connecting with fetal personhood, but everyone fully understands when you say giving fertilized eggs and fetuses legal rights. Like people get that immediately. When they get that, they don't like it. So
Mhm.
I don't know that there's a less of a mouthful way to say it, but that's the way to say it, is that we are in a moment where people are trying to give fertilized eggs and fetuses legal rights. And those legal rights that people are trying to impose are always going to be in conflict with the pregnant person, that those rights are being taken away from, not adding to the life and the liberty of that pregnant person. And to root that in the 14th Amendment is an affront and a complete disrespect to the fight of abolitionists in the 19th century to end the human trafficking that had built this country. And so to kind of twist that legacy and to twist the development into this kind of nasty brew that we're seeing that is justifying all of the pregnancy criminalization in this country is it's terrible. And I hope that by using language that's clear and forthright, we can start to actually address what that theory is making happen.
Thank you. Yeah, I think on that point, the term abolition is another thing that's come up in Cindy's article titled True Abolition. And there was a question from the audience. I think someone was confused about the like this sort of like twisting of abortion abolition. So I'd love if Cindy or someone else could explain like how that term has been co-opted. And then also, I would also love a discussion about how you all conceive of abolition when like many, again, in Cindy's article, a lot of the policies we talk about are like reformist policies. So how do you reconcile trying to like honor abolition in a true sense, but also be working within the confines of these systems?
I think I heard my name, so uh, I'm sorry. State the question again. What did you want me to say?
For anyone, I was also thinking of Cindy specifically, but just about,
Abolitionism,
yeah.
specific to abolitionism.
Mhm.
Well, I can speak about the article that I just wrote because I focused very heavily on the 13th Amendment. And the 13th Amendment, I believe, is the embodiment of all of our grant to personhood status. The 13th Amendment grants us personhood status. There's a variety of moves that I think makes it make sense for me to say that. When it comes to abolitionism regarding the rights of fetuses, I shake my head because I don't fully comprehend it, to be honest. And that might be because my educational beginnings, my foundations were in understanding that the Constitution is a liberal document. It gives rights to individuals, that unborn beings have never been considered individuals under the Constitution, that we run into trouble sometimes when we have conflicting rights. So, for example, when I teach family law, sometimes it's difficult to give a family rights. In history, it was not so problematic because we gave the rights to the man, and that was that. But in modern history, with evolution, gratefully, there are multiple parties that may have rights, including, of course, the woman in the situation. Abolitionism, I think, is just their rhetoric, I think, inappropriate rhetoric. I think more appropriate is for us, again, to re-co-opt the ideas of personhood, as this conference is trying to do, and designate them specifically to individuals who have been oppressed, to individuals who are indeed citizens and should be able to claim citizenship status. And I don't mean that to be another division, not at all. But there are so many ways that women, regardless, are not treated as persons, are not considered full citizens. I should mention the reason that citizenship is on my mind is in the piece that I'm talking about. I also talk about Dred Scott. So citizenship status is significant to personhood status. Persons are the ones, again, who are granted rights under the Constitution. Citizens have rights under the Constitution in ways sometimes that non-citizens don't. But that's not my focus. I don't mean to bring that into division or to make things divisive. I think that's so maybe someone could talk more about abolitionism when it comes to fetal rights, because I know very little about that. I just know that I don't like its use. I think it's inappropriate.
Uh, I mean, I feel like I had abolition in my title, so maybe I'll address. I mean, I agree absolutely with Karen and Zanita. Part of the reason why I have reference abolition in my title is just because it is so absurd and offensive. The abortion abolitionists trying to take on the mantle of
Mhm.
the abolitionist movement to end slavery. So what I was trying to do was sort of say, like, if we're really talking about abolition, we should be talking about abolishing laws that criminalize pregnancy outcomes and abortion. And that would be both, I think, and Margaret was talking about this, and other people are talking about this as well, not just getting rid of criminal abortion laws, but stopping the use of any kind of law, right, to criminalize abortion or pregnancy outcomes. So my piece doesn't directly address, I mean, and I feel like there are a lot of people who are fighting for abolition of all criminal laws. But I do think, like, as we think about abolishing criminalization of pregnancy and pregnancy outcomes, it actually forces us to confront why criminal laws are problematic, right? In terms of the racist ways that they're enforced, in terms of the classist ways that they're enforced, in terms of the way that prosecutors have incredible discretion, right? I think that in some ways, like, it's interesting for reproductive justice people or reproductive rights people to be in the space, because I think it makes many people see the things and the problems with the criminal system that they didn't see before. So I think that it's that's sort of interesting. And I'll also say that we worked with Pregnancy Justice on some advocacy at the UN, where we actually raised up this problem of over-criminalization in the United States, both looking at criminalization of pregnancy outcomes, but also criminalization of homelessness, criminalization of sex work. Like, right. So just, we have an addiction to criminalization in the United States. And I think that it's important for us to sort of raise this, not just our issues, but other issues.
If I could just hop in and stand on what you just said, Cindy, I think that the other kind of use of abolition has been about prison abolition. And I think that there's, again, like when we're talking about pregnancy criminalization, you can't take this, it doesn't just belong in the space of reproductive justice, it belongs in the broader tent around criminalization, period, and the criminal legal system, period. And, Andrea Ritchie has a phenomenal book called Let This Radicalize You. But one of the things that she says there is that, criminalization is how fascism manufactures consent. Because when you criminalize people, you get people to behave in ways and give up their rights in ways to justify these reasons for the criminalization. And we saw that with the war on drugs in the 90s and how it was used to completely pathologize and criminalize Black women who were using cocaine during their pregnancies, right? So it's a creeping, growing web, and it's something that we have to be very mindful of, both for its roots in enslavement, but also for how the long tail of that enslavement has touched the criminal system and the prison industrial complex. These things aren't kind of unlatchable. And so this conversation is really important to place these freedoms in the repro space in the broader landscape.
Thank you. This is really interesting. I want to turn, building off of that, onto another sort of concept that's being reframed in this discussion, which is property and like the property model of pregnancy. And Professor Mutcherson and Karen, you talk about like there could be this framing of a property model of pregnancy, but it's quote instantly uncomfortable for obvious reasons. And I want to like hear more about like how do we use this property model and make it about bodily integrity as opposed to like owning oneself as property.
Yeah. So I'm gonna start that. So the fun thing about writing a piece with somebody else is the importance of compromise. And so, one of the first long conversations that we had about writing this piece together, that this idea of using property came up, and I was like, nah, that's not a thing we're gonna do. I'm super uncomfortable with that. I don't want to talk about human beings as property. Obviously, our history suggests that we are not good at being able to split the idea of property from personhood. And I had a really, really strong reaction to that, both in terms of thinking about chattel slavery in this country and Black folks, thinking about the idea of coverture, right? The idea that when women got married, they disappeared into their husbands, basically, and so became property in that sense. The very long period of time, and some people would say we're still in it, where children were considered to be the property of their parents. So I think we need to be super, super cautious about how we use that language. And so the way that sort of that we came together around the use of property was thinking that the only context, and then I'm going to pass it over to Karen to fill this out. But the thing that got me on board was thinking the only context in which I certainly am comfortable with the idea of talking about property within bodies is the ways in which we own ourselves, right? So whether we're thinking about things like, we can go back to Henrietta Lacks and her cells being used for, all these years after she died. But those cells were her property, right? And she had an interest in them. And so there should have been financial remuneration, all those sorts of things. So that's how I am thinking. That is the only way in which I'm comfortable talking about bodies as a form of property. But let me throw it over to Karen.
Yeah, we sat down and Kim was like, I'm not doing that with you. So I think that's like the beauty of this moment. One thing I say a lot is like things are burning down around us, but in those ashes are real opportunities, real moments to create new things and have this kind of like cathedral thinking about working with the law in a way that is not for this moment, but for the 50-year period ahead of us, the 100-year period ahead of us. What are we going to do for the things that are beyond our time, right? And so I think when we shift the access or the axis on how we are thinking about the world and go from the folks who define property because they own property, right? And this is the Constitution. Like it was very clear about who it was meant for, right? And they state it very clearly. So we change that access and we think of ourselves as the center. If we are the self-possessed person and we do not create these false lines in pregnancy to justify the separateness. And I think this goes, we see this in things like viability bans, when we put them in ballots on, state ballots across the country as a way of preserving abortion rights, when in fact it is making criminalization more possible. And I encourage everybody to check out our friends Patient Forward and their work, because that the work of collapsing this ability to invite the government in to make the body public when it is a private body is the kind of the core of so many of the problems that we're thinking. And so when I talk about this unenumerated right, I do think that there was a space in the founding fathers where they recognized in the cathedral thinking things were going to change. Like they knew that slavery was not going to last forever. They knew that you can only kind of limit the rights of women for so long. I think that there was a little bit back here that was making that noise. And the ninth opens up the space to re-enter the public sphere with the ability to name the things that were not nameable 200 years ago. And so I do think we have a real legal opportunity to use this to name bodily autonomy and to name the wholeness of persons.
I want to add one other thing that I didn't say before, but I think is also really important here, which is in talking about property in this context, I also want to make sure that we don't run into the problem of then thinking about a fetus as the property of the person who's pregnant, right? Because that's not what we're saying either, right? And that, there's much room. And part of the problem is that in our larger conversations, both about law and about policy, it's often really difficult to talk in complicated and layered ways, to talk about nuance. And yet, if we want to get to a place where we're really sort of regulating in a way that makes sense, we have to be able to think about complicated things. We have to be able to talk about nuance. And I wanted to sort of bring in another strain of work that I do. So I do a lot of abortion work, but I also do a lot of assisted reproduction work. And one of the issues in that context has been, how do we think about embryos, right? When two people are fighting over how to use embryos. And what courts have had to do is decide, well, are we going to treat them as property? Not necessarily. Are we going to treat them as people? No, not necessarily. Where can we find some way to recognize that a human embryo is an entity to which we potentially owe some kind of special respect, which is the kind of language that courts have used, but that doesn't make that embryo property, nor does it make it a person. And that's a space that I think can be really fruitful for us as we talk about the law of pregnancy.
Thank you. The last sort of thing I'm thinking about in terms of language and reframing concepts is trans justice and bringing in a conversation about how reproductive justice intersects with trans justice. I think that this is something that's like so often like missing in conversations about reproductive justice. And I noticed that a lot of you opted for gender inclusive language in your articles. And I think, this whole question of bodily integrity and property, like, also is really relevant with the increasing criminalization of young people seeking gender affirming care, where it's like the conversion of their sort of body, sex at birth into like a public thing and their anxieties around that. So I'm curious as to how you're all thinking about this. I'm also curious, Margaret, in your article about the constitutional amendments. I think we're seeing like in New York's Equal Rights Amendment, gender identity and pregnancy were both sort of coupled as the things to add to the Equal Protection Clause. So I'm just curious about those things, if anyone has thoughts on that, or particularly Professor Johnson.
Sure, thanks. Yes, of course. I think what's really interesting about the theme that we're seeing across the different panelists is what Kim said starkly, which is we created a whole body of law relating to gender and reproduction, pregnancy, birthing, that's really been focused on abortion, this very small segment. And your question really brings that to light. one of the things I love about the Maryland state constitutional amendment is that it focuses on reproductive freedom. It's including but not limited language. And so, yes, indeed, I argue that it does include issues relating to gender affirming care. It's quite broad in its breadth, and we get out of the boxes that we see when we are creating very limited protected classifications under, say, equality principles, and also getting out of the box of, is it privacy, is it equality, is it something else? I really love that the Maryland constitutional amendment is so much broader than that. And you know, it's written with such specific language about what the state must do directly and indirectly, and what it must not do, and providing a legal standard that I think is unbounded by Roe, Casey, Dobbs, any of that. It's really an open terrain for new law, that we have a chance to be very inclusive, which we must be, and use, you know, especially in Maryland, where we have a lot of legislative activity around gender affirming care, shielding laws, same for reproductive care. So we have an opportunity to be quite expansive and not be bound by the limitations of the federal Constitution and where it stands now, but even where it stood before. Yes, and to this extent, when, you know, my next piece is looking at all the state constitutional amendments that have been passed relating to reproductive freedom and reproductive decision making. We see more choices, as Karen was talking about, where they may be enshrining like a Roe and Casey standard that I think is limiting for all the reasons we've talked about. They sometimes have been expansive about what will be satisfied by strict scrutiny, by looking at specifically like the personhood of the pregnant and birthing person as the viewpoint, really eradicating anything relating to prenatal personhood, to use Cindy's language, which I love. So more to be discussed with those other state constitutional amendments, but I do think this idea of making sure that we are gender inclusive when talking about these items. Obviously, that's a big mission of pregnancy justice and very important to reproductive justice. And obviously, it's all encompassed in that. And oh, I was going to say, when I've presented this paper, sometimes people have asked me, why am I not focused on, say, women, or we have an equal rights amendment in Maryland's Constitution. And I'd say, well, those are very limited to formal equality, very sex limited. And we need to make sure we're being as inclusive as possible. I mean, this time demands it, but also humanity demands it. So that's a long answer to your question, Sunil, but I really appreciate the question.
Thank you. Just a quick follow-up on that, since you mentioned other state equal rights amendments. I am curious as to, I liked when you mentioned like focusing on Maryland and like, even though it's a blue state, like just like raising awareness that these things are happening. I'm curious about how much you know about like New York's constitutional amendment, where the Attorney General's office is sort of arguing that it's not self-executing, and that, you know, maybe there was this win with this amendment, but it's actually not going to maybe lead to some of the positive changes in policy or lawmaking like you write about.
Yeah, thank you for that question. I certainly have more to learn about the New York case and what's happening there, but I can speak to Maryland. We have specific law about whether or not amendments are and provisions within our Constitution are self-executing. And of course, there's been no litigation relating to our constitutional amendment, but there's really good arguments that it is, because it does provide specific language. You know, Maryland's law talks about the difference between, is this just a provision that is proclamatory and sort of talking about the ideal version of what we hope and aspire to, or is it giving specific direction to the state and saying how this amendment will actually play out? As I said before, it does give very specific information to what the state can or can't do, and provides a standard by which that's going to be evaluated. So I think there's a good argument based on our case law relating to self-executing constitutional provisions that this is indeed. But as you point out, we will have litigation, no doubt, on this amendment, and we will see what happens. But that's my argument for the Maryland constitutional amendment.
And can I just also say one thing about these state constitutional amendments? State constitutions are incredibly important. They have done a lot of really deep work. But at the same time, let's talk about Missouri, right? Where they got a ballot initiative, it passed by a majority. And then the state legislature in Missouri was like, yeah, we're not going to work with that. And has now done all of this stuff to make that entire process basically get erased. It's really stunning. So you think about Dobbs, right, where Alito told us if you have issues with abortion, then that's what the democratic process is for, and we are seeing that fail so spectacularly. So on one hand, it's great, right, that we have this grassroots organizing that's happening. At the same time, though, there's still a lot of work to be done because the opposition is unwilling to actually believe in the democracy that they told us is what's going to save us.
And
Thank you.
and I'll just add, I mean, this also just, Kim, you're absolutely right. And it also just brings us back to this issue of prenatal personhood, right? Because like at the heart of that is the desire to attack the legislative process, right? So like, I mean, obviously we've seen gerrymandering, whatever, but the goal is really like if they establish rights for prenatal life, then they'll say they're going to strike, they're going to say that you can't make abortion legal. Right. So it's really about subverting the democratic process. Also, I just want to underscore, and everyone knows this, right? But how insane it is and such a sleight of hand to say that we're claiming rights for prenatal life when actually what we're doing is we're creating a mechanism for the state to control people, right? It's not actually about like the prenatal life asserting any rights or exercising rights. It's actually about expanding state power. So I just want to underscore that.
You
And
are so right on that point in particular. When we talk about granting rights and personhood status, rights is where we failed in Dobbs. And if we're now granting rights to fetuses and to human biomaterial over the rights of the genitors, of the gestators, of women and other people who are able to gestate, which hasn't happened yet, but I hope it does someday, right? If we do that, then we are ceding everything. It is the individual that has rights. And Dobbs made that very clever move, that sleight of hand, as you put it, to avoid granting rights, granting or acknowledging rights of a woman so that they didn't have to deal with it. If there's another body or another entity that's granted rights, then they have the full constitutional rights. They have the deference of the courts, at least under traditional law. And so that is the most troubling thing that I think has come out of this conversation, that women are no longer rights holders, but fetuses might be. That's going to keep me up at night.
I think next there's a few questions about the Ninth Amendment and the history of the Ninth Amendment for those scholars. And then also I know there's interest to talk more about like surrogacy of oppression. I leave it to all of you to kind of whichever you want to tackle.
I just want to make it very clear that I am not a Ninth Amendment historical scholar. I am a practitioner who is looking for legal opportunities. I think we're in a moment where there is a deep distrust of the ability of the law to serve and protect the people, right? And so there are options in that at that crossroads, like you say it's not a place in which I want to work, or if you are an attorney, if you're a practitioner, you do decide that it is the place you want to work and you want to reinforce it, or again, you want to do that generations ahead thinking about how are we going to use the law to create and to strengthen interconnectedness and care for communities. So for me, looking at, first of all, I think there are two issues here. There's first the creation of the Ninth Amendment in the Constitution, and secondly, the basis for how we use it and the basis for the idea that one's own self is entitled to be one's own
property, that you have a proprietary interest in yourself. And I think those two things are separate, but having that proprietary interest is what roots the Ninth Amendment in the right. So we have a constitutional, the unenumerated right that we need to express is that right to one's self. And I think that we've seen it in so many other places. We Kim, for instance, like one of the things that she was very clear and quick to add to our piece was the idea that parents do not have a right or do not have an obligation to provide certain medical treatment to their living child, right? And that kind of influences, that shows that people understand that there is an individual right. That doesn't disappear when you're pregnant. It doesn't get reinvented prenatally, right? So when it comes to the ninth, for me, it's about how do we effectuate what is already there? How do we create a constitution that represents the entire country and not just billionaires, white male billionaires, which it was when the Constitution was written, and which is actually currently happening now and never actually stopped in between.
So I want to say two things. So one, on the idea, I too am not a Ninth Amendment scholar. But there are lots of really smart people in rooms who are having very deep conversations about how we move forward from this moment and how we do so in a way that's different from what we have been doing. So I'm excited to see what comes out of some of those spaces. The second thing I'll say in that regard is that if we sort of think about unenumerated rights, one of those has certainly been a right to bodily integrity that does not exist, right, as enumerated in the Constitution, and yet the courts have consistently, for some people, protected that right in various ways. So that is certainly something to build on. And then I wanted to also say something about surrogacy. So as I said, I do abortion, but I also do a lot of assisted reproduction work and have written about surrogacy in various ways. And going back to what I said about the importance of nuance and complexity, on the other side of what was already sort of shared about some of the very deep legal and ethical controversies that come up in the context of surrogacy, as well they should, is also thinking about, well, what does it mean for us to say to a woman in a developing nation who says, this is the only way for me to make the kind of money that's going to allow me to care for my family? Now, the big level answer to that is we should have a better world. And that is certainly something that we are all building towards, but that's not the world that we live in now, right? So how do we have a system that, one, recognizes agency for all women, right? Not just women who happen to live in the West, but women who are potentially living in really difficult circumstances and need to find and choose to find ways that allow them to better their lives. And hopefully we will find other ways for women to do that, but certainly being a gestational surrogate for some people is a better road than, say, going into sex work, which might not be what they want to do. So, those kinds of questions. And then the other thing that I wanted to say about that as well, just to be really clear, in the United States, at least, and we need more data on people who work as surrogates, but in the United States, at least, we're not talking about poor women, right? We are talking mostly about women who are, lower middle class, maybe, and maybe even middle class. We're often talking about white women, and we're talking about folks who are saying things like, oh, I wanted to, we wanted to buy another car, or we wanted to get a bigger house, or we wanted to, pay for our kids' private school, or for our kids to go to college. So it's a really complicated landscape that looks different in different parts of the country, and that certainly looks different in different parts of the world. But I think it's so important for us to recognize the agency of women who are working as gestational surrogates. We want them to be protected, obviously, but we also don't want to infantilize them.
Thank you. This has been so great. I want to kind of build on what you said about building a better world, and like that as our sort of like North Star focal point. We're right at time, but I would love to hear just a little bit from each of you to close us out. Someone had a question about like how do we balance that reimagining while also engaging in harm reduction? And I personally also like wanted to hear, it's cool to have a mix of like practitioners and also scholars. So I want to hear about like from the scholars, like how do you sort of try to bring a decolonial approach to like the ivory tower of legal education? And then, how does that intersect with this work specifically in terms of social justice? So I'd love just like a few sentences from each of you, if possible.
I'll go first. So I always call myself an academic activist. And what I mean by that is, I did not go to law school to be a professor. I went to law school to be a public interest lawyer. Who knows how life does things to you, right? So here I am 20 plus years into a career as an academic, but I think that there is enormous power in being a person who thinks of scholarship not just as something that you are writing for other people in the academy, but that you are writing for people who are making policy, that you are writing for your students who potentially are going to go out into the world and do really wonderful things. Really sort of thinking about how do we use law as a tool, right? Law is never the end. Law is a tool that allows us to work towards justice. And if that's the way that we are thinking about it, both in how we teach, how we write, and how we do our jobs, I think that that's the right way. That's the right way to do it, at least from my perspective. Other people obviously have other thoughts about it, but I think that that's probably true for all of us who are sitting on this panel right now, and that there's tremendous power in that, right? That we are doing something that's very different than how the academy, certainly how the academy functioned, 50 years ago, but probably even how the academy functioned 25 years ago.
And I'll follow that just because I follow Kim wherever she goes. But I actually was in academic worlds before I went to law school. And the reason I went to law school because I felt like I wasn't able to do things that I wanted to do. So I think that, again, yes, as Kim said, the law is a tool. But I think one of the things that happens when you are, in my circumstance, when you're a dyke, when you're a Black woman, when you're a first generation American, is you go to law school and you start reading things and you just start reading how you are written out of the entire scope of the law. So I bring that to the work because our clients are written out of the law, literally. They are written out of the law in favor of their fetuses. And so I think we have an obligation to turn that. Again, it's that axis shifting. We have to turn ourselves into the center of the law that we're using. And to your question, Sunil, about kind of social justice, I am going to say this everywhere I go. I think for the next few months, but we are in a moment that feels hopeless, and I just want to talk about hope because I do think it is seen as this kind of gentle Tinkerbelly thing with like fragile wings, and that is not what hope is. Hope is a prize fighter. She has got a busted lip and a bloody nose, and her clothes are torn, and there is gravel in her shoulder, right? Because she's fighting and she's getting knocked down and she gets up and she gets up and she gets up. And so I'm hoping that today's conversations and what we're talking about will help people understand that we are here to land punches. We are here to fight back. And that doesn't mean that we're going to do it without being hurt. That doesn't mean that we're not going to do it without losing. It means that we get up and that we keep going. So I do hope that if there's anything anyone takes from today, it's that we're just at the beginning of this journey. And also, you want your Ninth Amendment. Thanks, everybody.
I'm happy to go next. I'm fortunate to be at a school that lets me both teach clinic and non-clinical courses. So for me, I've always written about the fact that there's a theory practice spiral, and there is no thing like Zanita was talking about. There's no such thing as like just theory sitting alone nor practice sitting alone. We inform each other all the time. And I love being at the intersection as that spiral goes around so that theory can inform practice, practice inform theory. To your point about harm reduction, Dobbs really stirred us all up. And, whenever we face great fear, we want to do something, right, and take action. And I think, of course, the most important thing is to think about the reaction to that action and go with the principle which we use in our clinic, which is harm reduction, right? Make sure that you're not creating an action that causes harm to others. And that goes with a decolonial lens, an abolitionist lens, making sure that you're not doing anything that further entrenches the colonial entrenchment of the law, as well as the carceral state. So you have to do it carefully. And a lot of times that means, like in my state, there's been a lot of conversations about what comes next, and it has to be done through those lenses to make sure that whatever happens is not causing further harm and not further entrenching institutions of power.
Cool, thank you. I don't want to cut anyone off, but just we are over time, so just a brief word from our other panelists just to close us out would be great. Thank you.
Okay, I've got three things I wanted to say, so I'll talk really fast because I don't want us to go much more over time. The first is partially a response to the work of Cynthia. It is interesting to me that the United States has never been a focal point for human rights, and maybe that's one of the reasons, and perhaps that's new framing for all of us is to start thinking about things in terms of human rights, because the United States violates human rights on a regular basis, but we never talk about it in that way. Second is about the language of inclusion. Always remember that inclusion and the language that we use, it's about the intention. It's not always about the language itself. Because I can talk about my intentions and what I'm writing. I guess I focused on Black women, but I also know that Black women includes transgender people, includes gay people, includes everybody pretty much, includes the range of hue, shades, and sizes. And so when I talk about Black women, I'm talking about everybody. When we talk about stuff in our case books, we always assume we're talking about white guys. So what is your intention behind the language that you're using? How can you make your point? And then finally, people are always surprised, or in this instance, they're surprised that I focus so much on property and finance and Marxism in this particular treatment. And so I can't leave without mentioning that it's important for us to do that with the current administration and the current courts. Internal criticisms of what the courts are doing has been in favor of finance and corporate interests. It has not been in favor of individual rights and tradition, not even originalism. And so finance has always been there. In fact, the first point I would make on the finance thing is the Constitution is embedded in property rights and in making sure that those interests are protected.
Um, uh, okay, well, I agree with everything everyone has said. I'll just make 2 points. One, I feel like one thing for lawyers and law students to think about is think about how the law actually is functioning, right? Because I think a lot of times people look at the law on the books or how systems are supposed to work and not how they work in reality. And we've seen this in terms of like pregnancy justice's work showing people were criminalized even before when we had Roe, right? So we need to like look behind the law to see how it's actually functioning. And the other thing is, it's been really like the lesson about just thinking about the long term, like Karen said, like as lawyers, we need to be developing theories for the future, for the long term, but also we need to learn the lessons from the past, right? So like I think that RJ critique of what was wrong with the Roe framework is incredibly powerful. And when we're seeing the drafting and creating new law, when we have the space for like the Maryland constitutional provision, right, it actually corrects a lot of the mistakes. Of the Rose standard, right? So like learning those lessons, learning from communities, what the problems are, and when we're in the spaces where we can draft new legislation or ballot initiatives, incorporating them. Thanks.
Thank you. Thank you all. It was an honor to introduce each of you and be in this space with each of you. And thank you for your beautiful scholarship. Sorry to go over time, but the next panel is going to start in like just a minute or so to give people a brief break. But thank you again.
Thank you, Sunil.
Bye.
Hi, everyone. Sorry for the brief break, but I did want to get us started for the second panel since we have some panelists that need to, unfortunately, leave us after this. Sorry, can you hear me?
I can hear you. This is Wendy.
Great. Okay. Hi, Wendy.
Hi.
Our other panelists could unmute. That would be fantastic.
Hi. Other Wendy.
Hi, both Wendy's.
Do you want us on video?
That would be lovely if you don't mind. Great. I think we have everybody. Okay, perfect. So hi, everyone. Welcome back, and welcome if you're just joining us for our second panel. This is the Impulse to Punish, an American Response to Pregnancy. I am Abigail, a recent NYU grad, former member of both the Reproductive Justice Clinic and the Review of Law and Social Change, so I'm very excited to be the moderator today. And here we'll discuss criminalization of pregnancy, bodily integrity, fetal personhood embedded in law, reproductive freedom, mental health care, modern concerns related to assisted reproductive technology and IVF, and then how we can better establish reproductive justice. So here we have another fantastic group of legal scholars. We have Wendy Bach, who is a law professor at Winston College, University of Tennessee, Knoxville. We have Kulsoom Ijaz, who is a senior policy counsel at Pregnancy Justice. Rebecca Reingold, an associate director at the O'Neill Institute, and Wendy Heipt, who is a senior reproductive justice counsel at Legal Voice. So thank you all so much for being here. First, we're going to hear from each of our panelists with a summary of their papers, and then we'll have a conversation guided by questions similar to last session if you were with us. And after that, feel free to submit questions while we're talking, and we'll return to those at the end of the session. So to kick us off, Wendy Bach, would you mind starting with what Dobbs got to do with it, pregnancy-related prosecutions in a post-Roe world?
Sure. Can you guys hear me?
Yeah.
First, I was a social change member when I was at law school at NYU, so always happy to show up for social change. I am presenting this work on behalf of a writing team, folks who are working with me and folks at Pregnancy Justice on the study of pregnancy related prosecutions after Dobbs. So Madeline Wasilczyk and Kendra Hutchins contributed to this paper. So I want to start with two stories. The first about the reporter's reaction to some of the preliminary data on that study, and second about a fairly recent statement by a West Virginia prosecutor. So first, the story about the reporters. Our study tracks pregnancy-related prosecutions in the first 3 years after Dobbs. We just released some data, which I think they're going to drop in the chat. But we define a pregnancy-related prosecution in that study as a prosecution in which the charge is based on allegations related to pregnancy, pregnancy loss, or birth, and in which the charge is based on those allegations. To put it more simply, the cases we document today charge pregnant women with crimes based on something that happened during their pregnancy. So, for example, a lot of the cases are around substance use and are charged as some form of child endangerment. So last September, we released our first report documenting at that time 212 pregnancy-related prosecutions since Dobbs. And when we released the data, we got one question over and over from the reporters. And the question was, in a sense, what's Dobbs got to do with it? Is this because of Dobbs? So the technical answer to that question is no. This has been happening for decades, and the prosecutions weren't really about criminal abortion. Very few of them are. Instead, they were prosecutions like the prosecutions that have been happening for a long time. So we told reporters that, and we told them that in a world of fetal personhood, prosecutors don't need the crime of criminal abortion or the holding in Dobbs to charge pregnant people with crimes based on their conduct during pregnancy. But honestly, that didn't really satisfy the reporters, and it didn't really satisfy us. So the second story is about a West Virginia prosecutor who recently explained that women in West Virginia could face prosecution for conduct associated with pregnancy loss. So he counseled that women should call 911 when they had a miscarriage. Many things were striking. One thing that was striking about this is that he wasn't say call 911 because you might have a health need that should be addressed. Instead, he was saying call 911 because you could be prosecuted and investigated for a crime. So that second story actually brought me a little closer to a better answer to the reporter's question. What is the relationship between the continuation of pregnancy criminalization and the end of Roe? I think the answer is complicated, but in short, it's two things. First, a strange marriage of the anti-abortion movement and the war on drugs laid the legal groundwork for pregnancy-related prosecution, leading us today to a situation in at least some jurisdictions in which prosecutors hold most of the legal tools they need to prosecute pregnant women for crimes associated with pregnancy conduct. And second, and after Dobbs, we find ourselves in a world in which there is no longer any shred of constitutional protection to support a pregnant person's choice about her pregnancy. And if we are to believe the West Virginia prosecutor, pregnancy loss is fundamentally suspect. As to the second point, our data suggests that after Dobbs, prosecutions targeting pregnant people specifically around pregnancy loss may well be on the rise. So ultimately, the marriage of well-developed legal architecture undergirding pregnancy-related prosecution, the lack of any constitutional protection, and heightened scrutiny of loss may well be undergirding a rise in these prosecutions. So I'm going to say a little bit more technical stuff before I'm done. So as to the legal groundwork, if you think about a prosecution of the kind I'm talking about, the prosecution needs strong legal ground to prove at least two things. First, that a fetus can be a victim of a crime that happens during the pregnancy, and that the pregnant person can be the perpetrator of that crime. So the status of fetuses as crime victims is, of course, part of a larger conversation around fetal personhood, and it stems from really two major trends. One was the attempt to instantiate fetal personhood in criminal law through the creation of the crime of feticide around the 80s, and at the same time, as part of the war on drugs, novel prosecutions, novel at the time, no longer sadly novel, in the 80s, targeting predominantly poor Black women in the South who were charged with crimes because they were accused of using crack cocaine during their pregnancies. So that gets you to fetal victimhood, but it doesn't get you all the way to a successful pregnancy-related prosecution. The second structural hurdle has to do with the perpetrator, right? The prosecutor needs to say, this person can be the person who perpetrated the crime. And when you think about the statutes, they really fall into two categories. Statutes that are about, in some way, pregnancy, think criminal abortion, think feticide. Most of those statutes, there's some nuance here, but most of those statutes actually exempt the pregnant person from prosecution. But it's in those other kinds of prosecutions, the majority of pregnancy-related prosecutions, that over several decades, as a result of litigations, prosecutors have in some jurisdictions successfully convinced courts that the perpetrator of that crime can be a pregnant person, and that the victim of the crime can be a fetus. So the essay lays out all of this in a great deal of detail. But the basic point is the architecture is there in some jurisdictions. They're hard-fought battles, as pregnancy justice knows better than I do, but in other jurisdictions, but that's the fight they are winning structurally, legally on the ground to get them to these prosecutions. So that's sort of the law part of it, but I want to return for a second to this question, are prosecutions increasing? And we will never know because of details about the data set, but I do want to talk about the pregnancy loss cases. So in our data set, we have 412 prosecutions currently documented, 31 involve a fetal or infant demise. 31 in 2 years is a lot of cases. If you look at Pregnancy Justice's former research documenting prosecutions between 2006 and 2020, there were about 120 cases, or about an average of 7 or 8 a year, that involved a fetal or infant demise. And while these data sets are not entirely comparable, there are reasons that we think that this may indicate that the numbers are going up, particularly with the prosecution of pregnancy loss. So in the end, prosecutors have the architecture they need, the cultural assumptions they need, and fewer constitutional rights in their way. So it turns out, at least with respect to criminalization of pregnancy laws, Dobbs may have quite a lot to do with it.
Thank you so much, Wendy. I'm looking forward to diving a lot more into all the things you raised here. But to keep us moving, for our next paper, a Catch-22, Mental Health, Pregnancy, and Punishment. Kulsoom, would you mind giving us an overview of yours?
Of course. Thanks so much, Abigail. Before I get into my paper, I want to give a fair warning, as you've probably guessed from the title of my paper, that for much of it, I do play the Grim Reaper. The piece walks through a matrix of harmful laws and policies that conspire to target and punish pregnant people living with mental health conditions. It also discusses where these laws come from, the motivations behind them, from deeply rooted ableism, the eugenics movement, structural racism, and classism that very much underpins the history of this nation and its present-day realities. And finally, it closes on a note of hope, drawing from abolitionist traditions and luminaries like Mariam Kaba and Dorothy Roberts, to imagine what divesting from carceral systems and reinvesting in care could truly look like. My paper opens with the sobering truth that the United States has the highest maternal mortality rate amongst comparable wealthy nations. And according to the most recently analyzed data by the CDC, mental health conditions, including deaths by suicide and overdose, are the leading cause of pregnancy-related deaths in the nation. These aren't mystifying realities. These are predictable outcomes of a nation that prioritizes harm and punishment over compassion and resources. Now, what do I mean by that? Well, if you're a pregnant person living with a substance use disorder, a recognized mental health condition, you could face decades in prison under Alabama's chemical endangerment of a child law, as you heard from Professor Wendy Bach. And in Idaho, you might find yourself placed on a child abuse registry. And this is all based on this idea that we can personify embryos and fetuses to have the same legal rights as you and I, precisely in order to take away pregnant people's rights, as Lourdes mentioned earlier, and what Professor Cindy Soohoo brilliantly names prenatal personhood. The anti-rights movement disingenuously tries to make it seem like it is pitting pregnant people against actual children, when it is really the pregnant person that is up against the might and the ire of the carceral state. These punitive responses to pregnancy and mental health are being deployed despite every major medical association in this nation stating that punitive responses to pregnancy do not work. It stops pregnant people from visiting their doctors because they're often deputized into the role of informants to report them, in turning what should be sanctuaries of care into sites of surveillance. People stay home, get more sick, and that is what drives up the maternal mortality rates that makes us the leading offender amongst our peers on a global scale. People living with mental health conditions are being hit by the criminal legal system from virtually every vantage point. On top of being criminalized themselves, the clinicians who treat them are also being criminalized, threatened with prosecution for delivering them abortion care. Many of the abysmal health exceptions in near total abortion bans across this country, the ones that claim to protect the life of the pregnant person, are written to exclude mental health. Many explicitly say a clinician may provide abortion to save a life, except when the risk arises from mental health or suicidality. Idaho's abortion ban is one of them. In the lawsuit that I helped the Center for Reproductive Rights file on behalf of patient plaintiffs and providers, the court failed in the end to protect pregnant people experiencing psychiatric crises under the ban's life exception. In this way, both the state's legislators and the judicial system decided against pregnant people, even though its own state-funded data, Idaho's own Maternal Mortality Review Committee, found that suicide and overdose were the leading cause of pregnancy-related deaths in the state in multiple yearly reports. Before I say this next piece, I want to say that many people living with mental health conditions do become pregnant, safely carry a pregnancy to term, they actualize their dreams of becoming a parent. But, our expert witness in that case, Dr. Jennifer Payne, who's a brilliant and prolific clinician and researcher, she's a reproductive psychiatrist out of UVA, I believe she's still there. She actually identified a biomarker that can predict whether pregnancy hormones could have an impact on a person's emotional health, such that somebody could become pregnant for the first time and for the first time be experiencing life-threatening symptoms like catatonia, suicidality, or psychosis. For some, the only path to safety is to remove the exacerbating factor, which is the pregnancy itself. Others depend on psychiatric medications that are unsafe to take in pregnancy after exhausting many times all other alternatives. So what happens? Pregnant people are trapped in a cruel catch-22. Those who would have chosen to terminate a pregnancy can't, because abortion care is criminalized in many of the states that criminalize pregnant people for merely existing. And those who remain pregnant face threats to their life and their health, surveillance, prosecution, and child removal through the very systems that claim to protect families. That's the first portion of my paper. The final portion is intentionally hopeful, and I'm really glad that the last panel of brilliant scholars ended on a note of hope, because I happen to be in my luteal cycle right now, in the luteal phase of my cycle, and I can be quite despairing at that time. But thankfully, the latter part of my paper was written at a time where I was more hopeful, and it really draws from abolitionist traditions to ask, what would it look like if our most powerful institutions and government agencies and actors banded together to protect pregnant people? The problem, I say, is not capacity, but sheer political will. We already have models showing us what compassionate governance can look like. I use the example of Washington because I spoke to a Washington family defense and drug policy attorney the other week, and she told me that it took Washington a decade to move away from their war on drugs, quote unquote, welfare queen, quote unquote, crack baby rhetoric and campaigning to move towards more compassionate healthcare. But they did get there. That model is asking hospitals not to report perinatal substance use and is investing its taxpayer dollars in wraparound services for pregnant and postpartum people navigating their emotional health, funding care to promote what's called the mother-baby dyad, which is just this fancy way of saying a mom and baby's health is inextricably linked to one another, and so should their health care. And I will stop there.
Thank you so much. Similarly, looking forward to really getting into a lot of these things. And last but not least, our final paper, Fetal Personhood on the Global Stage, the United States as an Outlier. We have Wendy and Rebecca. Could you please give us a take on that?
Thank you so much. Thanks to everyone. I'm going to start and talk about how this collaborative article came to be, and then Rebecca and I will work together to summarize the article itself. So we wrote the article because we and our third author, we shared a really big interest in fetal personhood, prenatal personhood. And we were talking about how this theory has been developed, who promotes it, what it means to pregnant people, what it means to pregnant capable people, how it's been successful and why, and really importantly, how we can oppose it successfully. And as we were talking, we realized that the fetal personhood movement, especially of late, has different trajectories in and out of the United States. So in the United States, the movement has really been gaining traction. But outside of the United States, in many other countries, it has not been gaining traction. It's been losing traction. And so that realization began what has so far been a 1.5 year long research project, whose goal is not only to lay out what's happening, but to share the advocacy that worked elsewhere with the movement in the United States so that we can defeat these efforts, so that we have access to other theories and other ways of combating these efforts. And in our research, we've explored so many areas in which prenatal personhood has impacted reproductive justice. And the article that we wrote for this issue focuses on 2 of those areas: IVF, in vitro fertilization, and subnational constitutional rights. And so we're going to go over just a very brief summary of what we said for either of those, and we're going to start with IVF. So in the article, we first explain what prenatal personhood is and the inroads it has made in IVF in particular. And the article starts by discussing that very infamous 2024 IVF Alabama case, which I assume most of you know, but just to quickly recap, 3 couples successfully used IVF, all had healthy children, and all were storing their unused embryos at a facility in Alabama. An intruder broke into the facility, dropped the embryos, destroyed them. And the 3 couples then brought a lawsuit under the state's Wrongful Death of a Child Act. And the case made its way up to the state Supreme Court. And state Supreme Court, in a very lengthy opinion, says that, yes, they can pursue a lawsuit under wrongful death of a child because those test tube embryos are, quote unquote, extrauterine children. It's a very long opinion. That's what it comes down to. No need for anyone else to suffer through it. And then in the article, we then highlight that while that case seemed extreme to many people in the United States, it really was a natural outgrowth and actually the long-term destination of many people in the anti-abortion healthcare movement in the United States. And in the article, we also show how while some states responded to the case by moving to protect IVF, a number of others moved in the opposite direction. And the case was celebrated by a number of factions within the United States. We also note that even at the federal level, Congress, before and after this case, has been unable to pass legislation to get enough votes to pass a law protecting IVF at the federal level. So all that to show that this Alabama case is not the outlier that many people who are not right in the movement think it was. And I'm going to pass it now to my co-author, Rebecca, to contrast the IVF experience in the United States with that elsewhere.
Thanks so much, Wendy. So globally, Costa Rica is one of the only countries, if not the only country, to have banned IVF outright. And the country did so in 1995 when the Supreme Court's Constitutional Chamber ruled that the destruction of embryos created as part of the IVF process violated the Costa Rican Constitution's right to life. Notably, the Constitutional Chamber cited international human rights law, referencing the American Convention on Human Rights' right to life from conception and other international human rights treaties' non-discrimination provisions. So 9 infertile couples in Costa Rica then filed a complaint against their government in the Inter-American Human Rights System, alleging that the ban violated their rights to private and family life, to form a family, and to non-discrimination. The Inter-American Court of Human Rights decision in this case, Artavia Murillo versus Costa Rica, has come to be known as the landmark IVF case in the international human rights context. In its decision, the court stressed that the question of when life begins can be evaluated from biological, medical, ethical, moral, philosophical, and religious perspectives. And accordingly, it's not the court's role to determine which theory should prevail and thereby impose one set of beliefs on an entire society. The court also examined other human rights instruments, jurisprudence from various countries, and global regulatory trends related to IVF, which largely permitted IVF, didn't ban it. And based on this assessment, the court ultimately held that the American Convention's right to life provision did not grant embryos and fetuses legal personhood, and that the IVF ban constituted an arbitrary and excessive interference in prospective parents' human rights. So with that, I'll stop and pass it back to Wendy, who's going to move us along to our next topic in the US context.
Thank you so much. So the second topic that our article discusses, besides IVF, is subnational constitutional rights. And I know subnational can have many meanings: state, locality, municipality. We focus on the state system in this article. And so in the United States, we have 2 US states that already have fetal personhood protections written into their state constitution. But they're not the only ones that have gone there. Others have tried. Florida, Nevada, South Carolina, and even more have actually put it on the ballot in their states for a vote. Colorado, Mississippi, North Dakota, not to mention the passage or attempted passage of fetal personhood laws in other areas of state law where this has been most active. So not only is it more frequent and more successful in the United States, but the United States has also normalized the conversation. So when this first came up in the US, it's been around for a long time, but the movement really took heart after the Roe v. Wade decision was published in 1973. That was the first year that a federal bill to establish legal fetal personhood was submitted to Congress. And in the years since then, there's been almost 300. And since then, when it was more of a fringe theory among religious groups, it's now part of a mainstream conversation that's been happening in the United States more and more. And that's also part of the problem that we're facing. And I'm going to contrast that once again with Rebecca taking the international perspective.
Great. So most, if not all, high courts that have considered a case involving the decriminalization of abortion have had to reckon with the constitutional value afforded prenatal life, which I think, Cindy alluded to in the previous panel. And we decided to focus on Mexico as the global counterpart here because of the same subnational dynamic that plays out there as does in the US. So one of Mexico's states decriminalized abortion care through the 12th week of pregnancy back in 2007, which then triggered a strong backlash. And 21 of the country's 32 states went on to amend their state constitutions to protect the right to life from conception. Abortion rights advocates and national human rights bodies then challenged the constitutionality of those provisions. And then in 2021, relatively recently, the federal Supreme Court in Mexico ruled that the state of Sinaloa's decision to extend its constitutional protection to of the right to life to embryos and fetuses back in 2018 was unconstitutional. And it held that because people become rights holders once they are born, the right to life is intentionally associated with the born person and not with the product of human conception. The court also echoed the Inter-American Court's decision in Octavia by stressing that it is impossible for courts and legislators to normatively and legally determine the beginning of human life. It also noted that a prenatal right to life would impose excessive burdens on women and pregnant individuals, restricting their rights to liberty, dignity, privacy, personal development, and reproductive autonomy. So as a result, the court ultimately held that there is no constitutional or international obligation to protect the right to life from conception. And so ultimately, our article argues that the recent success of the legal fetal personhood movement, the prenatal personhood movement, stands in the US stands in stark contrast to broader global trends. Decision makers in other countries and international bodies are generally moving in the opposite direction, recognizing that while an embryo or fetus has value, that value is not identical to having the legal rights of those who are already born. And before I hand things back over to Abigail, I just want to quickly acknowledge our third author, Paulina Macias, who I believe is a participant today, and we're so grateful for all of her contributions to this article. Thank you.
Brilliant. Thank you so much. I hate to interrupt us, but we have to give the CLE code for those that are looking for that. It is blurred. Oh, bodily autonomy. Sorry. I think it's because my background is blurred. Give me 1 second. I'll unblur it. You can see the code. There you go. Bodily autonomy. Okay. And now we can get back to some questions. Amazing. So many threads to pull. But let's start with Wendy Bach, because a couple of things you raised are very interesting here. And one of the distinctions you make is how abortion law primarily focuses on providers, which is interesting because it's traditionally thought of as like family law statutes that we're looking at that are applied to pregnant people. So could you dive a little bit more into this and tell us what that means for pregnant people, and then how we might start to disentangle this prenatal personhood and some of these narratives that are embedded in statutes like child endangerment and child abuse?
Yeah, I mean, so just as a sort of the background, so the crime of criminal abortion in almost every state, there's still a self-managed abortion criminal statute on the books in Nevada. The crime of criminal abortion itself in every state excludes from prosecution the pregnant person. So the perpetrator is presumably the healthcare provider or someone else who meets the elements of the statute to perform the abortion or assist in the abortion. And that's a whole other complicated thing. But the pregnant person herself is generally excluded. Same with feticide to a large extent, although there's a lot of ambiguity in some of those statutes as to the crime of feticide. I mean, the rest of the vast majority of the prosecutions, however, that's really not a problem for prosecutors because they're charging general criminal law statutes, some of which I think what you're referring to are in like a children's code within the criminal code, but these are not family law statutes. These are criminal statutes. So homicide, right? Child abuse, criminal child abuse, not civil child abuse. Also tremendously significant in the field, but those are the prosecutions that we're really talking about. In terms of disentangling, right, there's, I think, broader movements around that this conference has been talking around getting away from this idea of prenatal personhood, or as I was talking about it, and very specifically about this idea that the fetus can be a separate victim of a crime. And, you know, when I talk about this, and I think with lots of talk, like you really have to think about this as like, this is, you know, we are talking about the body as a crime scene, right? And it is a really irrational idea unless you sort of buy a lot of ideas that folks have been working for decades. And as we just heard from Wendy and Rebecca, right, does not have to be this way. We can conceptualize these things very differently. So there's a sort of a much more difficult and long ongoing movement piece to this. But from a litigation perspective, this is getting fought out every day, and it gets fought out on statutory interpretation. It gets fought out on legislative history. It got fought out in the courts around, you know, and I think there are interesting state legislative things going on in places like California. So, you know, the work is really hard, and the work happens at multiple levels to get that, you know, to fight back against this. But, you know, I think it's really important to just take a step back and think, that's right. The idea that the person carrying the pregnancy can commit a crime and it's all inside her body, that's crazy, right? But it's not, right? We have gotten there through other people's efforts, and it's that idea we have to, until we can really expose that and fight the fight to get rid of that idea, these prosecutions are going to continue.
Absolutely. Thank you so much. And this reminds me of another question I had for Kulsoom, which is how do we work with the medical community then to regain the trust of pregnant people when we've sort of, as you say, have this like patriarchal surveillance regime? So how do we shift that for them as well?
It's a big question. You know, what I would tell clinicians is to know what your laws say and don't say, and what latitude they give you to provide safe and compassionate care to your patients. I think I can give you the example of Wisconsin. I was just giving a talk to clinicians yesterday about the matrix of laws and policies impacting pregnant people there. And, you know, Wisconsin has a civil confinement law called Act 292, or known more pejoratively as the quote unquote cocaine mom law. And that law allows the state through the juvenile court system to take custody of a quote unquote unborn child, i.e. the pregnant person, and subject them to jail or home confinement based on the mere suspicion that they may use substances during pregnancy. Many times people are reported by their healthcare providers, and then the Department of Children and Families opens an investigation. But when you zoom out of that law and you look at the policies and laws that are in place in Wisconsin, you will find that the law requires clinicians to provide informed consent before they drug test a pregnant patient. Now, the thing that I love about my job the most is I get to work with clinicians. And many clinicians who work with perinatal patients tell me, you don't need to test your patients. Many times you can have a dialogue and a conversation with your patient and figure out what a plan of care is, right? So that's step one. As a threshold matter, don't test your patients. The second is the law says that you may report a pregnant person who has a positive toxicology. It doesn't say you must report them. So don't report your patients. And then lastly, looping back to Act 292, the law is vague, right? It doesn't clearly define unborn child abuse, and perhaps that's a gift, right? You know, Pregnancy Justice brought a case on behalf of a person who was impacted by this law, and a federal court found the law to be unconstitutionally vague. Now, the Seventh Circuit, you know, overturned that decision because the plaintiff moved out of state and the case became moot. But the fact still stands. The law is unconstitutionally vague. And so, you know, clinicians are really in this incredible position to read the law in their patient's favor. And then I think this also dovetails in the second part of your question about the patriarchal surveillance regime. You know, clinicians are also in an incredible position to be advocates, you know, with all of their gravitas, the backing of their clinical education and research and the actual patient populations that they serve, to highlight just how harmful these laws that punish pregnant people living with mental health conditions actually are, and of course for pregnant people writ large, right? And so I would encourage clinicians to become advocates, to engage in policy work, right? Getting rid of the patriarchal surveillance regime in a state is going to look different from state to state, right? Because every state is different. It depends on whether you want to take an incremental approach or a more full-throated one. But I can tell you what our North Star is, right? And I can give the example of Colorado. Colorado has this law called the Reproductive Health Equity Act. Now, that, of course, states explicitly that pregnant people, surprise, surprise, have fundamental rights. But it also explicitly disavows fetal personhood, and it states that the state cannot punish or prosecute a pregnant person based on their pregnancy status. Now, the word punish is in there quite intentionally. I spoke to framers and drafters of this bill. The word prosecute basically speaks to how the criminal legal system can't punish pregnant people. The word punish speaks to how the family policing system can't punish pregnant people. Now, that's all good, right? You know, that's one step towards fighting the patriarchal surveillance regime. But we often find that, you know, rights that exist on paper don't always play out in practice. Professor Cindy Soohoo spoke to this, right? About, you know, really impressing upon practitioners and law students that, you know, please interrogate, how is the law actually functioning, right? And that's where civil rights lawyers become really important. We need to hold state actors that don't faithfully execute the law to account. Recently, you know, even despite the fact that Colorado has a Reproductive Health Equity Act, someone had their newborn taken away for alleged drug use during pregnancy, right? And so it's going to be important for civil rights lawyers to hold people's state agencies and state actors' feet to the fire and hold them to account, but then also AG's offices, right? Attorney General's offices, and investigating these state agencies and how compliant they are with the existing framework that intends to protect pregnant people in the state. And I'll stop there.
Thank you so much. So many great things there. We've gotten a couple questions in Q&A about it, so I'm going to start to introduce the idea of IVF into the conversation, just so we can cover some of that. So first thing, generally, broader question, what do you think we should be prepared for the future, since IVF is a little bit newer on the scene, falling into like reproductive issues? And then we have specific questions in the chat where people are trying to disentangle the disconnect, where it would seem like abortion opponents would be against IVF, and so how we see that play out then.
Thank you. I'll start and then I'll tag team Rebecca to come in with the international perspective. And the first part of your question, I believe, was the issues in IVF we're following. And I'll start with that. I'll start with the impact of the Alabama IVF case that I already told you about and the impact of that in and out of that state. So in the state, while there was celebration in some quarters, there was also panic. And some moved to protect IVF within the state of Alabama, which was imperfect, but did provide a measure of protection to some clinics. Still, one clinic is closed, one has destroyed embryos, and one has moved embryos out of state since that decision. So that impact is profound. Nationwide, there was a lot of concern around storage facilities, transports. Were people going to be responsible for extrauterine children? And in effect, as we say in the article, for frozen nurseries, where there are going to be frozen nurseries of actual children around the country. And individuals were concerned about the cost and availability. And that Alabama decision relied on a lot of religious language and also a state constitutional amendment that recognized the sanctity and the rights of the unborn children that went into effect after Dobbs. And that state constitutional amendment was based on a vote from citizens in that state. And that vote was sold to people as a values vote and not as a rights vote. So what they were told was that if you value pregnancy, you necessarily must pass this amendment, but don't worry, it won't really change the rights of what's going on in the state. So in addition to the many areas that we're watching that you probably all can guess, insurance coverage, availability, cost, procedures, storage, employment law, transport issues, civil wrongful death, criminal liability, we really have this values question that we're struggling with as a movement, the values versus rights question. And that's an issue we're also watching, how to message that. I know this came up in the last panel too, the question about messaging, which is such an important question because we are struggling with it in some states in the country. How do we disentangle the often very profound value of a pregnancy to an individual, a community, or religion from the legal rights of that pregnancy? So that's a very big issue. And I can talk about the states we're watching or go into your next question. What's better for what's
Whatever you prefer to talk
Okay,
about.
so the states, I would say the states we're watching every state because this comes across in every US state. Of course, there are a few that are at the top of the list. Louisiana, because they already take all IVF embryos out of state because of a 1986 law giving embryos judicial person status with some limited rights. And in their last legislative session, there was actually a proposal to stop even that, where you could not have even shipped embryos out of state if they were going to be possibly destroyed out of state. We're also watching Arkansas because that's the other state that has the constitutional protection for prenatal life. And they also have other indicators that are quite worrisome. For example, if you have an end-of-life directive in Arkansas, that's fine unless you're pregnant. And then you must be kept alive unless there's a possibility that fetus can develop to live birth. We also had some troubling legislation in Arkansas's last session, proposal that clinics had to report all the embryos that were created, destroyed, or shipped. So that kind of surveillance coming into the embryo system. Watching Iowa, they had a proposal last year that you would be liable for causing death of the unborn. Of course, Texas, we always watch Texas. In the last 60 days, Texas had a special session, a legislative session, and there was a proposal in Texas's literally 40 days ago where a child would be fertilized at birth and it removed any penal code that protected IVF so that had it passed, IVF would have had no protection for anyone involved in IVF in Texas. So also the other usual suspects, Arizona, Idaho, Ohio, Tennessee, Indiana, South Carolina, the list is long. That's what we're watching quite a bit. And then I think can you repeat the last part of your question, Abigail?
Yeah, we had a question raised in the chat of someone grappling with this issue. You would think that people that are anti-abortion would also then be opposed to IVF. So how you're seeing that, how to understand that.
That's a great question. And I think that goes to IVF exceptionalism, which is and it comes up in a couple of ways. If you're against abortion healthcare, some people still say they're okay with IVF because that's selective reduction, which is just an abortion by another name. And some people who are fetal personhood proponents carve out an exception for IVF. Some don't believe these exceptions. They all want to get to where fetal personhood actually exists, but they say it because of the popularity of IVF. So they have all kinds of terms for this. Even the storage facilities, they say that's not actually abandoning rights-bearing children. That's part of the family building process. So they have all kind of linguistic ways to exceptionalize IVF from their actual agenda. And in addition to these legal gymnastics, that whole practice promotes good and bad ways to reproduce and good and bad abortions, which is very problematic because it hierarchs what is acceptable and what wasn't, as if that's up for anybody else's debate. And it's hypocritical, and it's also inequitable because IVF is expensive. Medicaid insurance doesn't always cover it. It's generally used by older, whiter, and wealthier people. And there's actually a great article written by my co-author here, Rebecca and Rolanda Donaldson, on that. And it's really hypocrisy, but it's hypocrisy being used to get to the place they all want to get to, which is that control of the pregnant capable people's life cycles and fetal personhood. And then I will pass it to Rebecca to add the international perspective to that.
Yeah, I don't have a ton to add, other than I think the Artavia case and the court's analysis really looks at how Costa Rica's ban is a true outlier in the IVF context. That was true back in the 90s. It's true to this day. And that it was important to understand, how our country is dealing with this. They're not banning it. They may be regulating it and regulating it in different ways, sometimes problematic ways, looking towards other countries. But the people who brought, the lawsuit that led to the ban are part of the same movement. And we see that playing out in other countries the same way we see it playing out in the US, that there are these links between the people who are advocating for these extreme bans, whether it be on abortion, IVF, certain forms of contraception, and that's true across borders. There may not be entire, unity throughout the movement, especially when some of these measures are less popular with the general public. But I do think it's a place we should also continue to watch what's happening in other countries, since I do think, unfortunately, the US sometimes is a trendsetter when we talk about regressive trends, and that maybe we'll see more attacks on IVF in other countries in the future as a result.
Absolutely. That's a great segue to another question that's sort of come up in the chat, and then also sort of tangentially in all of the questions we've asked so far. And that's, could you speak, this question for everyone, more about the role of capitalism and the carceral industry and how they've played a role in policing pregnancy? And that is, I know, a very broad question, so however you want to take that.
I'll start, even though it is a very broad, and when I think about carcerality, right, like I think, and Kulsoom referenced some of this too. I mean, when I'm thinking about how it plays out on the ground, right, thinking, right, I'm thinking about an entire system of actors, right? The carcerality of healthcare spaces, the carcerality of family regulation spaces, and just the sheer number of people who are engaged and paid to engage in this enterprise. So, just to give you one little piece of the data of the 412 cases, 264 of those cases, in the criminal complaints or in the probable cause affidavits, we saw information obtained and disclosed in a medical setting. Like the number of individuals who are engaging in surveillance policing and are participating in this enterprise of criminalization and of surveillance is really, really, really striking. And so when I think about like the day-to-day of carcerality, I think about like who's being paid to do what, right? Who's paying for the drug test, right? Who's making money off the drug test? Whose job is it to police the ER to come, right? And what that sort of very extensive network of human beings who are participating in the prosecutions we're studying are doing. So that's not an entire answer to Iman's question, but it's a piece of it that strikes me as we do this research.
And I just want to add, I know this might not answer Iman's question entirely. I do want to talk about just how long this has been happening. Pregnancy justice has been sounding the alarm on these cases before Roe, under the Roe framework, and now in this post-Dobbs landscape. And then I also want to say and clarify who's paying, right, for these carceral policies. The Reason Foundation did a briefer on, how state laws and policies and state actors respond to substance use during pregnancy. And in that briefer, they talk about just how expensive it is for our taxpayer dollars, right? Like our taxpayer dollars spend an average of $33,000 annually just by incarcerating a single person. It's more than $70,000 in states like California and New York. And for separating one child from their family and placing them in foster care placements, that costs taxpayers an additional $25,000 a year per child. And so I really do want to keep asking the question, like, what would it look like if we divested from these carceral policies and funneled our investment into safety nets? I don't think we would be living in a world with the most damning maternal mortality rates.
I'll jump in. It's a big question, so I'll just have to take a little part of it. And the part I'm going to take is surveillance and control. So if we had a full fetal personhood system in the United States, the state would have to rely on other actors to support that system. People would have to step in, and we're seeing that all the time by having actors deputized in the abortion healthcare context to turn in other people. So medical folks, as already been mentioned, instead of being places of safety, would be people who turned in anyone that they worried about, and we all know who they're going to worry about. License plate readers, geofencing, the whole femtech, data shares, friends, actually turning in friends. We've already had cases where that's happened. And all that are steps in the ultimate control of pregnant and pregnant capable people. And by control, it's a slippery slope. And when I talked about this a few years ago, I sounded like I was a conspiracy theorist. And unfortunately, it doesn't sound that way quite so much anymore because it's happening. So it's what you can eat, the jobs you can have, how much care you have to take crossing the street. All of these things are already happening because, and I think this was an actual term used in the last panel, that once you're pregnant, your body is no longer all yours. So if your body is no longer all yours, whatever you engage in is now subject to the state, because the state is now hierarching two fully constitutional rights holding persons in one body. And they're not trusting the pregnant person to make the decisions. So they get to hierarch, and history shows us that when they do that, the pregnant person loses. It's the potential life that always wins until they're born, and then they don't care about them. So we're already seeing, there was a case, I think this one is in Canada, is a judge was giving someone a sentence, but because she was a sex worker and pregnant, the sentence was doubled because of her profession. We had someone stopped for a DUI. They were not over the legal limit, but because they were pregnant, they were taken into custody. So we're already seeing the emergence of two sets of rules based on pregnancy or not pregnancy. The underlying theory is that we can't trust the pregnant person. We can't trust them to make the decisions that are right for them, their family, their community. So, but your question, Abigail, could be a whole other panel. So we could keep going on it.
All right, we're almost at time, so I'll give us one last question and then we'll unfortunately have to wrap up. So I really loved in the last session kind of ending on something that was a little uplifting, a little bit of hope, a little bit of direction. So similarly for this, we're seeing a lot of problems with pregnant people as perpetrators, and that's a huge issue. And so how can we change that narrative? How can we center the experience of marginalized people and then truly support reproductive justice? I'll let Wendy Bach start because I know you have to jump.
All right, I do have to jump in like 30 seconds, but I'm just going to say I have the great privilege of working extremely closely with folks at Pregnancy Justice. And so I get to do research alongside and hopefully in support of their work. And they're the ones that give me hope. They are working, and it's not just them, but like folks are on the ground every day fighting on these stuff. We talk, I talk to lawyers a lot. I talk to advocates a lot. I talk to them a lot. And there's brilliant, creative people doing good work. That's what gives me hope. And now I have to go. I'm so sorry, but thank you for the great conversation.
Thank you, Wendy. Other thoughts? Feel free to jump in.
I'll jump in. I think what's also giving me hope is not just all the smart people involved in trying to do this and all the committed people trying to give hope about this, but also the movement from just listing what's happening to opposing what's happening gives me hope that people are moving to some action. And I'm having more and more conversations in different spaces about how we can share tactics, how we can share strategies within the United States and even beyond borders, so that we're not just writing down what's happening, which is important, of course, but we're also talking about, and here's how we can oppose it. And I find that very, hopeful. Although overall, there are very dark days right now, but I do find that hopeful.
I can follow Wendy because it does build on what she mentioned a bit. I'm an international human rights lawyer by training, so a lot of my work on these topics is in the context of other countries. And while it may sound quite depressing to say, what gives me hope is knowing that unfortunately other countries have been there, are there. I do think it means that we are connected to a broader movement that makes us stronger and can provide solidarity in these moments that can feel incredibly challenging and incredibly depressing. So reaching out, connecting with, facilitating connections between my colleagues here in the US with the folks that I know doing this work in other parts of the world is really what I'm focused on right now, and seeing how it can inspire hope and creativity and innovation across borders is where I'm at. And the other thing I'll just add is that I do think in this moment we spend a lot of time about, now that we're rebuilding from scratch, because a lot of what we relied upon has been completely decimated by the courts in particular, that there's a moment to really embrace human rights norms and standards, which came up in the previous panel. And I think there's great opportunity there, even if it's a long-term strategy, even if it's arguments for the dissent right now, and it's going to be a long time before we can see this actualized in certain spaces. I do think there's a lot of opportunity there to respond to the challenges we're facing. So.
I can go if that's okay. This convening is giving me a lot of hope, to be perfectly honest. I mean, just hearing from folks in the reproductive justice space, in the reproductive health and rights space, folks that, are taking the time to summon defiant hope, right? In this increasingly hostile climate. It is a practice, right? It's not something that's second nature, and it's not toxic positivity, right? Toxic positivity ignores the hellscape that we're in. Defiant hope looks at it in the face and dares to have courage. And I think that's what I'm getting from a lot of people that are working in earnest in this space. And people with disabilities, pregnant people living with mental health conditions, are deserving of hope, just like any other class of people. I take a lot of hope from people who believe that it is not easier to tear things down than it is to build it up. It is only a difference of will. If the anti-rights movement can defund things like research and science and safety nets and funnel our taxpayer dollars into ICE raids virtually overnight, we can do the opposite. And the other thing that gives me hope, I think Wendy touched on this earlier, our clients give me a lot of hope. Our clients have had unimaginable cruelty visited upon them by the criminal legal system and the family policing system, and they have stood up, taken that hatred, distilled it, and transformed it into loving themselves and their communities, and fighting back and saying, whatever happened to me cannot happen to someone else. They are stunning alchemists. And, in days where I am feeling despairing or losing of hope, I just remember them. And that's what helps me get up in the morning and to do the work that I'm doing.
Thank you so much, all. I feel like that's a great note to end on, and we are a little over time, and I apologize for that. But again, thank you to the panelists for taking time to discuss. It was a wonderful conversation. And we'll be taking a little bit of a break on our last panel, where junk science meets gender stereotypes. Will start at 12:30, so I hope to see you all there.
Hi, everyone. Welcome back. We're going to get started with our last panel of the day. My name is Maeve Wiesen. I'm a third-year student at NYU Law, and I am a member of the Reproductive Justice Clinic, and I'm also on the board of the Review of Law and Social Change. So I'm so thrilled to be here and to have these wonderful panelists here to discuss our panel called Junk Science Meets Gender Stereotypes. Our three authors that we have written really fascinating pieces about the criminalization of pregnancy and pregnancy outcomes, how ideas about good and bad motherhood play into the phenomenon of criminalization, and how discredited or incomplete evidence can often support prosecutions. So like the previous panels, we're going to start by hearing from each of our authors as a summary of their piece, and then we will have a discussion. And like the other panels, if you have any questions, please feel free to use the Q&A function, and we will try to get to as many questions as possible throughout the hour. So our first piece and our first author is Janet Levit, who's a professor at the University of Tulsa College of Law, and her piece is called The Criminalization of Pregnancy in Oklahoma, Comanche County, and Kay County. And please correct me if I pronounced any of that incorrectly. So I would love to hear more about your piece. And yeah, thank you.
Thank you so much, Maeve. And it's just a real honor to be here and sharing this space with so many people who've been inspirational to the work that I've done. And I just want to set the scene a little bit in Oklahoma. So for most people, Oklahoma is flyover country, so have not been here. But here are some data points. Until about 3 years ago, Oklahoma ranked first in the country, which meant first in the entire world in female incarceration rates. Due to a couple diversion programs, we are now, I think, third or fourth. Oklahoma ranks last or close to last in almost every reproductive health indicator. We have one of the strictest abortion bans in the country. And if you've been following any of the news in the past couple of weeks now, every single doctor in the state needs to sign a pledge that they will not engage in abortion-related activities in order to access Medicaid funds. And so it is really unsurprising that Oklahoma is second in the nation in pregnancy criminalization. And for the last 2 years, I have been leading the reproductive justice practicum at the University of Tulsa and working with Rebecca Reingold, working with Dara, Gell, and others from Pregnancy Justice, indirectly with Wendy, Bach on their project. Our students have been involved in gathering some of the Oklahoma cases that have fed into their project. And what struck me in the process is that in 2 of our counties, we have 77, in 2 of them, Comanche County, which is way in the western part of the state, Kay County, which is in the northeastern part of the state, over half of all cases that were brought under felony child neglect charges were pregnancy related. So they were a super high percentage. And I'm just going to use my time to summarize like how Oklahoma's law creates super fertile ground for these prosecutions and what the process generally looks like. And in the discussion, I hope we can dig deeper into the pregnant people at the heart of these prosecutions. So I'm going to try to share my screen, see if this works. Okay, I think I'm successfully sharing it. But
You are.
So there are 3 sets of law that come together in what I believe is a perfect storm for these kind of prosecutions. The first is our felony child neglect statute, which states that or makes a felony out of willful or malicious exposure of children to the use, possession, sale, or manufacture of illegal drugs. And on top of this, we have a court decision, and many on the panels that have preceded this one have spoken about the role of the courts in furthering prenatal personhood. But we have a court decision called State versus Green about 5 years ago, which defines child to include the fetus. And anyone who reads that decision, I teach it to my students every year. It's a very tortured analysis because it borrows the definition of child from the criminal code, even though the statute, even though from other crimes, even though the statute directly references the definition of child from our sort of juvenile welfare statutes. So it's a very tortured analysis, but now the statute is applied to fetuses. The second law is our mandatory reporting laws, which are mandatory. There's no discretion, and that sort of doctors or providers or anyone must report to the Department of Human Services, which is our child welfare department, must report any positive infant test indicating substances in the system, or must report any suspicion of substance use. And so it's also particularly that suspicion, which has a lot of places where discretion can be exercised or not exercised. And then in the regulations that implement the laws as they pertain to our Department of Human Services, the investigative process is mapped so that every investigation that the Department of Human Services opens actually has to be delivered to the local DA's office, regardless of whether the investigation is substantiated or unsubstantiated. And so these cases end up on almost inevitably in DA's offices. And that is one of the main ways that the criminal justice system is able to get a hold of these cases. And so the process, I looked at the cases in Kay County and Comanche County. There's 85 of them. And the process is remarkably similar for almost all of them. It starts with either the pregnant person being tested for substances or admitting to use of substances, either upon admission to the hospital to give birth or at some point during prenatal care, a prenatal care visit. That creates the suspicion of substance use that usually results in a subsequent infant test to confirm the presence of substances. And this all of this is then reported to the Department of Human Services under the mandatory reporting rules. And they report it to a hotline. And that hotline does have discretion to screen cases out. It only uses that discretion in less than 1% of the cases it receives of dealing with infant substance exposure. So then, regardless of what the investigation bears, the report goes to the DA's offices, and the DAs have really unfettered discretion, even if a report is unsubstantiated, to file felony criminal neglect cases. And then the way that these cases generally proceed is that they end in a plea. None of the 85 that I've looked at have actually gone to trial. Like 2 or 3 or 4 have been dismissed, some of with the help of pregnancy justice. But what is sort of dramatic about these cases is the plea ranges in Kay County were from 3 to 15 years.
mostly deferred sentences. And the deferred sentence involved both community service and not treatment, but parenting classes. Parenting classes in, wait for this, a crisis pregnancy center or an anti-abortion center. So the last panel talked about like who is actually getting paid through this carceral process. One of the beneficiaries, at least in K County, is their crisis pregnancy centers. In K County, the sentences range from 5 to 25 years, deferred or suspended sentences, and successful completion of drug and alcohol rehabilitation. I will say many of these cases, particularly in K County, were based on charges related to marijuana exposure or and some kind of THC derivative exposure. And in Oklahoma, we have medical marijuana is legalized, and many, I mean, more than a few of these women, particularly in K County, had medical marijuana cards and were prosecuted anyway. That seems to have slowed because of the good work of pregnancy justice in a case called Aguilar, which came down just about a year ago. But there have been proposals in our legislature to explicitly make marijuana an illegal drug, which would again open the door to criminalizing marijuana charges. So that's just an overview of how this happens on the ground. I think I'll wait for the questions to talk about the women, who they are, and some of the demographics involved.
Thank you so much. Yeah, I'm really looking forward to diving more into who these women are. Our next paper is No Crime, Reproductive Wrongful Convictions by Valena Beety, who is a professor of law at the Indiana University Maurer School of Law. So Professor Beety, take it away.
Thank you so much. And thank you really for this incredible symposium. It's been amazing to hear from so many people. I'm going to share my PowerPoint. I hope that likewise it works. I'm going to do what Professor Levit just did. Does this look right? Okay, great. So I come to this space as a wrongful convictions litigator, as someone who researches wrongful convictions, and I am also a law professor in Indiana where abortion is illegal. And so my work really has been connecting what we know about wrongful convictions and no crime wrongful convictions, particularly of women in the past, to these reproductive charges today. And prosecutors are emboldened by our abortion bans to charge, as we know, pregnant people with crimes due to their pregnancy behaviors. And this often has either no scientific evidence or relies on junk science. I'm sure many people out there are familiar with the case of Patience Frazier, which thankfully has received national attention. But Patience is in Nevada, and she was convinced by police that she had caused the demise of her fetus, that she had caused her miscarriage because she had intentionally consumed a large amount of cinnamon. So Patience falsely confessed and ultimately pled guilty. And it wasn't until post-conviction litigation that Patience finally heard from experts that she had not caused the demise of her fetus. And her conviction was ultimately reversed. And the conviction was declared a total miscarriage of justice by the judge. So how can we understand this strategy of criminalization? We've been talking about this a lot today, and how we can challenge it, what tools we can use to challenge it in court. I have a forthcoming book next year with the new press, Pink Crime, and it tries to draw this through line from looking at past wrongful convictions of women to understand the strategy of criminalization and challenge it today. And so what I see as relevant is, again, looking at these past no crime wrongful convictions and identifying how junk science has played a key role, gender bias, and false confessions. We see all of these with Patience Frazier. We can already identify how people are being targeted for pregnancy and parenting behaviors, but connect that with the historic control that states have had reproductive decision making by labeling mamas as unfit during our eugenics period. And moving forward, I've previously written about and advocated for Daubert hearings in criminal cases, definitely. But we have a new Supreme Court case this year, 2025, Brenda Andrews case, Andrew versus White, and it's a way to challenge biased evidence. So generally, it's important to know that women are more likely than men to be convicted where no crime occurred. These are all images of women in the United States who have been wrongly convicted where there was no criminal act. And what do I mean by that? That means there's an electrical fire, and yet the mama is charged with arson and with felony murder via arson. And I use the term mama as gender inclusive. So these are all women. And in the top left is my current client, Tasha Shelby, who is incarcerated for a no crime wrongful conviction. Hers is typical of other types, which is a child who has already been born, but a child is suffers some catastrophic accident or has a natural cause of death, and the mama is instead charged with murder or with child abuse when there was no criminal act. So these are actually accounting for nearly 75% of wrongful convictions of women in the United States. For men, the number is closer to 25%. And these are generally, again, faulty forensic evidence cases. And again, they're frequently child death cases. And what we see here are that these mamas are being punished not for what they did, because they didn't do anything, but for who they are perceived to be. And faulty forensics and gender stereotypes fill in the gaps. So that there's this narrative of guilt that is created where, again, no crime has occurred. And the Supreme Court has recognized that faulty forensic evidence wrongly convicts innocent people repeatedly across the spectrum of our Supreme Court. And yet courts continue to admit faulty forensic evidence. Fire science, bite mark evidence, and today against pregnant people who miscarry, who deliver stillbirths, or who test positive for a controlled substance before or shortly after delivery. And quickly, I do want to flag how this language from eugenics of unfit to procreate or parent is cropping up again today, is being used today. This enduring label that has remarkable staying power overlaps with race, class, disability bias, and it's being used as both proof that there was a crime, that there was a criminal act, and proof that this mama is guilty. And we've heard a lot about contemporary pregnancy policing, but junk science is playing a role in this. We have, again, pregnant mamas who are prosecuted for drug exposure, even when it's been a hospital-administered drug. We have unconfirmed drug tests that are used as evidence. We have false positives that are presented. And then we have cases where there was no actual harm. And as Wendy Bach notes, that these charges only present an alleged potential risk of harm. So there's this shifting from punishing actual harm to punishing risk and behavior. And then, as I think we'll talk about more, the faulty forensic evidence used for charges where the state has to prove a live birth. It's a charge of homicide. As Wendy said, these are using our standing criminal statutes that are in place, like homicide, like child abuse, to then go after these mamas when there's been a stillbirth, or also when there's been a miscarriage. But how is a live birth proven by the state? It's very difficult to prove a live birth. after the fact. And so there's this reliance on faulty evidence there as well. So how do we move forward? Again, I always encourage Daubert hearings, but there is this case that I think we should all take note of, Andrew versus White from the Supreme Court this year. And Brenda Andrew was having an affair, and her lover shot and killed her estranged husband. She, for that, was charged with capital murder. She is the only woman on death row in Oklahoma, as Professor Levit, I'm sure, knows. It's an unusual capital murder case. Normally, this would not be a capital murder charge. She had no violent background. She had no criminal history. But what the state did have was this evidence of adultery, which continues to be a crime on the books in Oklahoma, and this evidence that she was a bad mom or a bad wife. So this included her lingerie, her underwear was shown to the jury. Would a grieving widow wear this? It included a book she had on how to drive a man wild in bed, and it included extensive testimony about her romantic and sexual relationships going back 20 years, completely irrelevant to the charge at hand. So the Supreme Court ultimately, in this case, said that it's a due process violation for gender-biased evidence like this to be admitted and to be used in court. It is unduly prejudicial. It fails the balancing test that's required of probative versus prejudicial, and it is a due process violation. And I also see how this can be used to exclude prejudicial, stereotype-driven expert testimony. I know I'm out of time. I just want to quickly say, again, I'm from Indiana. I'm in Indiana. And we are the first state that passed a eugenics law that allowed the state to take the reproductive capacity of people who were deemed unfit by the state. But I do see evidence as a hopeful way out of our current situation. And I look to this law because what is often lost is that this law was challenged, this law was suspended, and the Supreme Court of Indiana itself ultimately ruled that this law was unconstitutional, it violated due process, and it ruled based on evidence. It was that someone who was going to be sterilized needed to be able to challenge the evidence, challenge whether the evidence was scientific, challenge whether it was reliable. So I do see some hope in our use of evidence in challenging pregnancy and parenting criminalization today. Thank you.
Thank you so much. Our final paper is Cold Case Pregnancy Criminalization, How Forensic Investigative Genetic Genealogy is Used to Prosecute Mothers for Decades-Old Stillbirths by Dara Gell, who is a senior staff attorney at Pregnancy Justice.
Hi. Yeah, that's a mouthful of a title, I'm realizing. Hi, everybody. Thank you so much. Last paper of the day. I hope that I still have some of your attention. I will try to be interesting. I am really grateful to be here and to be on this particular panel. I want to commend the organizers because I really feel like you set me up perfectly to go after Professor Beety because my work is really following exactly what she's talking about here. So I've written about the rising use of forensic investigative genetic genealogy. The shorthand for that is FIG, and I'm going to call it FIG. And we're going to talk about it in the context of pregnancy criminalization, in particular in tracking and prosecuting parents of previously unidentified fetal remains. This has gotten some coverage recently, most notably in a New York Times article with a really frustrating headline. But certainly when I started working on these cases about 1.5 years ago, folks were not discussing this pattern of cases. And so I'm really happy to talk to you all about it today and for my paper to come out. So first, really briefly, and if you know me, you know it's hard for me to talk briefly about this, but I'm going to try. What is FIG? FIG is it was popularized after the arrest of the Golden State Killer. So if you're interested in true crime, maybe you've heard of it. And what it is it is a method of combining DNA testing and ancestral searching to allow police departments and civilian investigators utilizing individually uploaded DNA code into public genetic databases to identify perpetrators of violent crimes or identify previously unidentified human remains. And again, to not go into it much now, my paper talks about it a lot more. This is using a type of DNA testing that has not traditionally been used in crime investigations, which is something called STR testing and is much, much more limited study of DNA. Instead, this is using SNP testing, which is what 23andMe and Ancestry.com use. And it's looking at hundreds of thousands of points in a person's DNA to look for ancestral markers, to look for data points of what you look like and health implications. Are you more likely to get Alzheimer's? It's really looking at your personal individual health information. And it's taking that DNA code and putting it into these public databases. I want to be clear, it's not Ancestry.com that's being searched. It's not 23andMe. If you have done those tests, as of right now, your DNA code is not being searched in those databases, but people are putting their DNA code using SNP testing into these public databases that police and really like private genealogy investigators are searching. And one category of FIG investigations that has emerged since the Golden State Killer was found in 2018, really, and since FIG has been popularized, is this type of case called the baby doe case. That's the moniker that's been given by FIG investigators. And baby doe cases involve extracting the DNA of unidentified fetal or neonatal, and I call this a perinate, remains, discovered often decades ago to identify the parent of that perinate. Those names are passed along to law enforcement who investigate them. And based on my research and the research of pregnancy justice, since 2018, there have been over 60 baby doe FIG investigations initiated across the country. And 34 parents, including 30 mothers, so the vast majority being the person who delivered the baby, have been identified and subsequently prosecuted under charges including, but not limited to, murder, manslaughter, abuse of a corpse, and tampering with evidence. And I have seen other charges across the country, but those are the main charges. These parents have received sentences ranging from probation to 20 years in prison, and in one case, up to life in prison. And the oldest of these prosecutions stems from testing on fetal remains that were found in 1981. So we are talking about decades old remains. And not all, but many of these baby doe FIG prosecutions, I believe, are pregnancy criminalizations. They are cold case pregnancy criminalizations, just like the criminalizations we've been talking about all day. Many mothers, when identified, described to police laboring and delivering alone, experiencing a medical or mental health crisis, and giving birth to a stillborn baby. They are clear that they delivered a stillborn. In the midst of their postpartum trauma, they dispose of the fetal remains and are often keep the painful experience private for decades until police officers arrive at their door with accusations of murder. In these cases, very often, despite being emphatic that they experienced a natural pregnancy loss, the mother is not believed, is deemed a baby killer, and is prosecuted to the highest extent of the law. And what makes these FIG cases really complicated defenses of pregnancy criminalization is a few things. First, that bad science that Professor Beety was talking about is, you will see throughout these cases. In most of these cases, in many of these cases, the prosecutor has to prove the baby was born alive. And you will hear from forensic pathologists that determination is nearly impossible to make, certainly from autopsy alone, and in particular in these cases. And you'll see a reliance on the lung float test, the floating lung test, it's called a bunch of different things, as well as other really problematic science that should not be and cannot be relied on to prove life, but is being used to prove life, or to at least threaten that it could prove life, to push people into taking Alford pleas and other kinds of pleas to manslaughter or other types of criminal pleas that they otherwise, the prosecution won't be able to prove their case using this bad science, but the threat of the bad science can push people to take these pleas. Other complexities, and I'm going to go really quickly, is both the issue of time. When you're talking about a cold case, you're talking about physical evidence getting lost. I come from the Innocence Project. I know a lot about lost evidence. And in these cases, you know, your defense expert might not have access to the fetal tissue and the slides that are making the determination of live birth decades ago. And then finally, the biggest difficulty with these cases is just the way that they have created a narrative in these small town communities where these fetal remains have been found. And this baby has been mythologized, right? So that this community has lost this baby at the hands of a cold-blooded killer mother who could do such an evil act. And the cops have been traumatized and the community has been traumatized, and they've written this narrative together about what has happened. So that when the mother is finally identified and says, I experienced a horrible pregnancy loss, and in a moment of not being sure what to do, or for whatever reason, I disposed of my fetal remains in a way that perhaps you disagree with. That community can't hear what has been told. They can't hear it was a pregnancy loss. And so a prosecution happens where no crime has been committed. And that's what Professor Beety was talking about, is these no crime prosecutions. And I have more to say, but you'll read the paper. But I just want to close by saying that these fig baby doe investigations are a new trend in an old story of blaming women for natural, blameless tragedies against fetuses and children. The technology of FIG will continue to be utilized against people who suffer pregnancy loss, extending past cold case investigations into real-time pregnancy loss, and I fear into abortion criminalization investigations. However, FIG by its nature can only operate with public support because people have to upload their DNA into a database. And if they are upset to hear that moms and grandmas are being prosecuted for their decades-old stillbirths, maybe they'll stop uploading their DNA. And certainly FIG is a highly unregulated field, and with regulation, there is potential to curb some of these prosecutions. That's what I got. Thanks.
Thank you so much, Dara. I'm really excited to dig more into what all of our panelists have talked about, but first I'm going to give you all the code for those who are trying to get CLE credit. The code is gendered forensics. So I'll keep this up here for a second. Gendered forensics. Great. Again, thank you so much to all of our panelists. I am just fascinated and frankly horrified by all of what you have written about. And my first question is, I was hoping that Professor Beety or Dara or both of you could just expand a little bit on the floating lung test, because I found out about it a few months ago and it's been like rattling around in my brain for months, unable to shake it. So if you could talk sort of more about what it is, its history, and also, I don't know if there's a good answer to this, but why courts are willing to accept a practice and other practices that are so clearly not scientifically sound. I'm very curious about that.
Well, I can start off with the salacious history, and then anything Dara has to add. And I'm so excited to see you here, and have really been glad about your FIG work and Pregnancy Justice's work on it. So thank you. So the floating lung test, again, different names for it, but it literally, folks, it comes from the Middle Ages. And it's this idea that if you take a newborn and you take a piece of lung in the autopsy, then you put the piece of lung in a liquid, and if it floats, it's full of air, the child was born alive and took its first breath rather than being a stillbirth. And then that is used as proof that the mama killed the baby. Okay, so it really has these powerful consequences. And as Dara said, it may not get to trial because that, that evidence sounds powerful enough to compel a guilty plea. But the problem is it regularly is false. It's not an accurate test. And it tends to have false positives, which means that the lung floats. So again, it's being used as incriminating evidence when it's not reliable hardly at all. Physicians for Human Rights have talked about this and written a guidance paper on it. But we continue to see it being used. And one of the key cases it was used in is out of my state, Indiana, with Purvi Patel. So that's kind of the salacious background to it.
Yeah, I'll just add, and it is such an honor for me to be talking about junk science in these cases with you, Professor Beety. You asked why courts allow it, and in part they allow it because people don't challenge it, right? That's why you have to file Dauberts. That's why you have to challenge these things. There is a growing recognition among medical practitioners and pathologists that there are problems with this test, but I think one of the big issues and the disconnects is that pathologists will just use this and then discredit the results, right? They'll say, we're doing the test, we teach the test for its faults, we do the test, and then we don't really count what the test says. But if you are an attorney and a prosecutor, you see a test result that helps support your case, you're going to bring it into the courtroom because a jury, more than anything, all they want to be told is that a scientist has looked into a case, gotten the answer. They are not at risk of falsely convicting somebody because a scientist in a white coat who knows what they're talking about has done this test, and they understand the lung flow test, right? They understand up, bad, down, good, right? And so it's simple and it's tangible. And so a prosecutor, even knowing, and a judge, even knowing that there are questions about the validity of it, they will take the fact that pathologists do this test and haven't thrown it away as a sign of its implicit support or validity. And so that's why it's so important to challenge this and to really try to keep it out. And I just also wanted to clarify, because I think it was a little confusing. I'm seeing some questions in the chat. In these cases that I was describing, the remains are found in public places. They differ. There are cases where they're found, the remains are found on the side of the road. They're in bathrooms. They're found in public places by the public, and what has happened to that infant is unknown for many, many decades. And then ultimately, the story of their death is revealed because cops interrogate these mothers. In every one of the cases I have seen, the cops have interrogated these mothers who ultimately share their stories of this pregnancy loss. So I wanted to take the opportunity to clarify that.
Thank you. And thank you for that answer. Those were very informative. I have a question for Professor Levit. I thought you talk in your paper about sort of the animus, the tone of animus and condescension in a lot of the probable cause affidavits and in charging documents. And I was wondering if you could talk more sort of about your findings in that area and how you view the people in power and the people utilizing their discretion as using their ideas about, good motherhood, bad motherhood as playing a role in these cases and in the lives of these women.
So thank you. Just to clarify, the documents that we looked at in these cases were charging documents and probable cause affidavits. Anyone who's seen them, they're very short documents. And what just really screamed from these documents was the sort of the bias, the notions of what a good mother, what a bad mother was, and how much irrelevant information was shared within those very short documents. So here's some examples. Remember, the felony neglect statute requires willful or malicious exposure to illegal drugs, and that includes fetal exposure. So here are some of the things that the probable cause affidavits identified. mothers who smoke, mothers who use alcohol, mother who had syphilis, none of which are illegal drugs or controlled substances. There were multiple, I'd say maybe half of the affidavits had comments about the level of prenatal care. Some of them said only intermittent prenatal care, no prenatal care, limited prenatal care, and this was just constant. Incredibly condescending, particularly in a state where over half of our counties are maternity care deserts. And that is increasing by the month, I would say. We are losing doctors and the places to give birth. There was one affidavit who talked about a mother who was homeless, and many of them went on at relative length on history of drug and alcohol use. Again, none of these relevant for the charge at hand, which was malicious and willful exposure of the fetus to illegal drugs. I will also say that I found the fact that in one of these counties, K County, where almost every one of these cases ended in some kind of prescription of parenting classes, not substance abuse treatment, but parenting classes. To me, that just underscored and emphasized that this was about mothers betraying what sort of the traditional and in many cases religiously infused conceptions of what motherhood should be and should look like.
Thank you. Yeah, sort of building on that, I would love to hear from all of our panelists about how they see gender stereotypes motivating and emboldening prosecutors and other state actors to go after people who experience pregnancy loss. Or, I mean, in a lot of cases that Professor Beety is talking about, child loss. So if Professor Levit gave a great start, and if you have any other thoughts. If anyone has thoughts.
I mean, I'm happy to start. I think that what Professor Levit has really locked into is vital here, and there are expectations of how women are supposed to conform as a mother, right? And so when you look at pregnancy loss cases, and you can look about it in the FIG context, you can look at all of the cases that we're seeing across the country right now about just disposal of human remains. So how somebody miscarries is trying to be prosecuted, to be charged them with abuse of a corpse, and other really horrific crimes. There is an expectation of there's an expectation of like profound grief that you are going to walk into the hospital cradling your fetal remains and sobbing over your infant, and you're not allowed to have trauma response. You're not allowed to clean up your blood after you've just had a horrific miscarriage in your bathroom. If that is an act of suspicion, right? Any sort of care for yourself or a moment of processing is viewed as suspicion, and that's all because we're being viewed as under the guise of what is good motherhood and what is bad motherhood. And if you don't conform to an expectation of what a good mother is going to do and all the ways that she's going to publicly grieve, and she is going to present as a perfect pregnant person, if you've in any way failed those expectations, then you are under suspicion. And I think that that's really what we see in these cases. It's what we see in all of the drug prosecution cases. But anybody who doesn't conform in pregnancy and in their pregnancy loss with what people think is appropriate are suspect. And it's a deeply, deeply frustrating thing to be a defense attorney for.
Yeah, and I'll just build off of that to say, again, I think we see a lot of these same trends if we look at past wrongful convictions of mamas for no crimes. We see not just what we've already heard from our other speakers, Professor Levit and Ms. Gell, about this encroachment of pregnancy behaviors becoming criminal. Did you eat fish and you weren't supposed to eat fish? I mean, were you wearing a seatbelt? So this expansion, this real expansion of the surveillance state into every detail of how pregnant people are behaving. And again, just to double down on this, it is through this lens of these mamas as being unfit to procreate or to parent. Again, this term from eugenics. And through that unfit lens, we have, oh, there was a crime that was committed. There was a crime here. This couldn't have been accidental. This couldn't have been, as Dara was saying, like a tragic stillbirth that like you, of course, didn't share with the world. And that was so hard for you. It's all through this lens that a crime was committed and you committed a crime. And this is also that lens of whatever your behavior is in response to police, that's going to be used against you and can be used against you. Did you cry? Did you not cry? What kind of comments did you make? And again, if we look at these past wrongful convictions, we see prosecutors who say, oh, look at this statement she gave to the police. There's no emotion in this statement. And then you have another case where it's like, oh, look at this case. She's clearly faking. She's feigning her response because it was so over the top and she was crying so much. There's just, once there's that lens and once you've been criminalized, charged, your behavior then is interpreted in that lens.
Because I think at the root of it, it's she's failed to keep this fetus alive. She's failed to keep, or in the case of, in wrongful convictions for a living child, she's failed to keep this child alive, even if it was a horrific accident in the case of these pregnancy losses cases, even if it's just a tragic stillbirth, she's failed in her obligation as a woman. Yeah.
Thank you. Another question. So something that we've discussed in the Reproductive Justice Clinic a few times, Kiara Bridges' article on race, pregnancy, and the opioid epidemic, white privilege and the criminalization of opioid use during pregnancy. And sort of the idea that prosecutions for opioid use during pregnancy appear to be instances of the states identifying and punishing a population of people who have been disloyal to their whiteness. And I'm just curious, I think that argument expands, beyond sort of the opioid use context. And I'm curious about the sort of demographics of the people and the mamas who are being prosecuted. In particular, I'm interested in, I noticed in Professor Levit's paper, I think in Kay County, there were a disproportionate number of American Indian women who were being prosecuted, but also just generally understanding, we're curious about how race and gender stereotypes sort of together play into these phenomena.
So I'll just start there and say, I think they play a significant role, as does economic status and like being an indigent status as is measured, at least in the documents that I saw, by whether you engage a court-appointed counsel. So I'm just going to share my screen for 1 minute because I have some of the demographic data of these 85 cases in a chart. If I can still share it. Did that work? So this just to put this up for a minute, really shows the disproportionate impact on American Indians, Native American, and indigent populations, and also just the prevalence of most of these prosecutions also are of white pregnant people. And so I wanted to just say one thing about the white privilege. I did go back, maybe after sort of thinking about this question, and looked at some of the sentences. And some of the longest sentences were of white women in the data set. I think there's still a lot of work to do with this data on, this is not a formal regression or anything, but I think there definitely was some correlation in the length of the sentence. K County itself is in the eastern part of the state, which is made up of we don't have reservations, but it's primarily Indian land. And so what's interesting about these numbers is they're actually probably a whole lot higher than this, because with McGirt, a lot of the prosecutions may be very well in federal court. And looking at, I'm working with some of my colleagues to try to find out how many prosecutions there are. So I think these numbers may really underrepresent the Native American women in this data set. So, I mean, clearly the numbers show bias, and the bias also comes because there's several points in the process where different actors have a lot of discretion, whether they're doctors in reporting, whether they are the DHS workers in deciding to investigate, or whether the DA is in bringing charges, and all of that we know is ripe ground for bias to seep in.
If anyone,
I can build off of that. So I think we also know, we see that Native populations are disproportionately targeted with criminalization laws in general. We see that with Native juveniles. And frequently our past demographic studies and research haven't necessarily included Indigenous peoples, particularly in states where they're a smaller population. But again, as Professor Levit said, not only is this a community that continues to be targeted with criminal laws, but also it's important to look at these federal cases, because under McGirt versus Oklahoma, which is this key case that says that the state is not going to have jurisdiction for criminal cases on a reservation. And so only the federal prosecutor can have jurisdiction. Most criminal law is state law based. So there's been this big shift. So Professor Levit, I think you're completely right to be looking at what's going on with what are ostensibly federal charges here as well. And then just more broadly, we always need to be talking about race, immigration status, economic status, and I'll also put in there, particularly in this context, disability, that just as we've talked about maternal care deserts, there's also a severe lack of accessible maternal care, even having, for example, an examination table that can move up and down. So there's a number of mamas with disabilities who cannot access prenatal care, and then that is used against them in the situations we're discussing.
I think that my fellow panelists have made beautiful points on this. I would just say, from the pregnancy criminalization research that we have done, I am not on the research team, but speaking for pregnancy justice, we recognize that the criminalization of pregnancy has deeply racist patriarchal roots, targeting poor Black, Native, and Latinx women, and has presented that way over the decades, in particular when looking at the legacy of the war on drugs in the 1980s. But in the mid-2000s to today, drug patterns have shifted, and the target of pregnancy prosecutions has reflected that shift to include the opioid crisis and the methamphetamine uses that are predominantly seen in white communities. So our research has shown, as Professor Levit has pointed to in her research, that the majority of pregnant people who are being prosecuted are poor white women, which signals to us that the tactics used to criminalize Black women are now being extended to poor white women, predominantly those poor white women who use drugs and who, as Kiara Bridges has pointed out, are being disloyal to their whiteness, right? Are being they are the failures to the white race by indulging in drugs and in failing in their motherhood, right? It's this same pattern of you are not conforming to the expectations, and so we will throw you in jail. It's just yeah, so that's from the pregnancy justices study component.
Thank you. One question that we have from the chat is something, it feels like what's being discussed, we've been talking about reliance on junk science rather than real science or public health interventions to respond to prenatal substance use or postpartum, crises, stillbirths. And so we have this person wondering if panelists could talk about how we should be processing and responding to these cases instead. What policies would we need that we don't have, and what would we need to dismantle? Big question.
It's a huge question, and one I will fail to fully answer, but I'll take a stab to start. But just to say, in the cases of women that I represent across the country who have substance use disorders, there's a lack of access to healthcare. There's a lack of access to substance use treatment. And when they're in Oklahoma, there's a lack of access to abortion care if they are struggling with the substance use disorder and they are in a position where they recognize that they might not be able to get the treatment because there is no substance use treatment or healthcare to raise a fetus and a baby in the way that they want to, but they cannot terminate their pregnancy. They're in this terrible catch-22 in which they're being forced to continue their pregnancy despite using drugs, and then they are, facing the criminal charges without any sort of resources that could have protected them. And so you talk about the real science and the real resources that are needed. People need access to healthcare. They need access to substance use treatment. They need access to pregnancy ending care if that's what they so choose. And simply yelling at people that they're not good, simply yelling at people that they're doing pregnancy wrong doesn't help anybody. It just continues a harm, and it fosters a situation in which the only resource to help a child after birth is through incarceration of their parent, which, as we all know from the science, doesn't help anyone.
I just want to add a little bit. I agree completely that access to healthcare is critically important. And one of our partners was presenting at our Capitol yesterday in anticipation of the legislative session. And one of the points of discussion were sort of safe harbor laws that if women, pregnant people were to be able to go to doctors and ask for help during pregnancy with substance abuse disorders without fear of being reported under mandatory reporting laws. And I believe some states have done that. And so that's something that is on the table, that I hope is on the table. Whether it will pass in our state is a big open question, but definitely we have some legislators who are going to propose that. And we also in Oklahoma, I can speak for Tulsa County, and I think Oklahoma County, those are Tulsa and Oklahoma City. There's been some very effective diversion programs in Oklahoma. In Tulsa, it's called Women in Recovery. That has been very successful at providing women with treatment and then having their records expunged. It is a deeply expensive, it's and very holistic, sort of 18-month program. And the success rates have been great. And I will say that even in our state, the state has started to invest and reimburse the private parties who are providing the funding for like successful cases. And so that's a model that could be replicated as well.
And I guess I'll jump in here on kind of support for pregnant mamas, specifically medically and for their health. As Dara was saying, and as we've talked about, kind of the criminalization of people in the opioid crisis, that if you're pregnant and even if you're taking treatment for a substance use challenge, even if you're taking prescribed buprenorphine, for example, which would be gold star treatment when you're pregnant because it's more safe to take that than to be going cold turkey and just stopping. So even when you're doing that, that can still be used against you. And this goes back again to like, so it's in your bloodstream. So again, like the science isn't able to fully show where this source is from, if it's from prescription bupe, if it's from something else. And the criminal legal system is manipulating that and is using that and is using these tests. For example, you cannot medically determine whether a miscarriage is spontaneous or whether it's medically induced. And yet again, we see these claims being made in that space as well. So I think we need to be aware of that. I think, again, the encroachment of criminalizing pregnancy behaviors just in the past few weeks, now it's been advised by RFK that pregnant women shouldn't be using Tylenol. And the advice is, oh, just, I wouldn't even call it advice. I'd say the response has been suck it up for people who are pregnant. So I worry about this. And as much as I talk about junk science, I do think we need to continue to have research and studies on what is reliable science, what is reliable medication, having medications for mamas who are pregnant, not just, oh, you have cancer, but you're pregnant, so we're not going to give you any treatment because of potential implications for the fetus. I really think we need to explore that space too.
Great, thank you so much. We're at time, and I feel like that was a good sort of forward-looking question to end on. So thank you so much to our panelists. This was really wonderful to hear about your work and your thoughts on these really tricky and important questions. So given that this was our last panel of the day, I'm also going to wrap us up more generally. So I just want to say thank you again to everyone who was part of putting this symposium together. So Pregnancy Justice, the Birnbaum Women's Leadership Center, the Review of Law and Social Change, the Reproductive Justice Clinic. Camille and Kelsey have been dealing with all of these logistics for us, so we're very grateful to them for that. All of these amazing pieces are going to be published in the spring in the Harbinger, which is the online side of the NYU Review of Law and Social Change, and I'm sure we will be sending out information when those pieces are published, so that I'm sure everyone is dying to read the full pieces after hearing these great panels. So thank you so much for spending your Friday with us. We hope that it was informative, and we look forward to working with you all in the future. Thank you.
Thanks, everyone.